Previous motion. Motion item 25.
25.
Motion item is meant to be listed next week.
Okay. That means the next Wednesday. Okay, next week. What are the measurements in next week?
Yes.
Okay. MS Shukri, learned additional advocate Nagaland, has sought for listing of the case in the before the division bench in the next week. Mr. Santianger, learned counsel for the sole respondent, has no objection to say fair. To list the case. List the appeal before the division bench in the next week.
Again, I have similar prayer in item 26.
Yes.
This matter also I pray to be listed next week in Lordship. I've taken the concern of the opposite party.
Okay. P. Supri, learned additional advocate in Assam for Nagaland, appearing for the appellants has sought for listing of the case, same, next week. First of, it is submitted that consent has been taken from the respondent side to make the prayer. First of, list the case accordingly.
Much.
After a week. Appeal. List the-
Yeah, please, Your Lordship.
Yes.
My lord, I beg to mention item number 6. My lord, if this can be listed again on 6th of December,
Okay, after 2 weeks.
my lord.
Yes. Hello? Okay. On the prayer of Aka Kichu Learned Council for the petitioners. Repetition means virus.
My lord,
Repetition?
challenging the rules. Yes.
Okay, virus. For the petitioners. The case stands adjourned for 2 weeks. MS Supri Learned Additional Advocate in Nagaland for the state respondents is in attendance. This is the case of the 2 weeks.
My lord, there is an interim.
Hmm?
Interim.
Interim order.
Yes, my
The
lord.
interim order passed by the shall continue till the next date of listing.
Yes. My lord, I also beg to mention item number 8. My lord, here, I have received the affidavit filed by the state this morning. So if this can be listed next week.
Okay, Mr. Takakichu, Learned Counsel for the petitioner has prayed for and is granted 1 week.
1 week time, my lord.
1 week time to file affidavit in reply to the affidavit in opposition filed by the state respondents. So, raise the case after a week.
Bless my lord.
May I please, Your Lordship, my lord, I beg to mention item number 15. Here I'm yet to receive instructions, so kindly allow me 1 week time. In the last occasion, I was directed to furnish the instruction whether the private respondent. was-
She has been appointed, there is no issue, she was appointed, right?
She was
Yes.
appointed, but the issue is whether she has joined the service or not. That is all.
She is appointed, so ultimately that issue is legal. I just asked you to obtain instruction because
Yes,
that
yes,
Whether she has
the single judge also directed
yes,
that she should be appointed,
yes.
right?
Yeah.
So 6 months, she must have been appointed, already appointed, joined or not.
Yes.
Law is settled otherwise, Mr.
Your Lordship, the order passed by a single page that has been suspended by this honorable court. By the different page.
At least Your Lordship, I'm for the private respondent. When she got selected initially, she joined for 1 month and she even drew salary for 1 month.
That is the issue. There is no legal point left.
Yes.
She joined, she walked. So we have to see the appellant's case, which has been dismissed. Okay, we'll wait.
Okay, Lord, sir.
No instruction necessary.
Okay.
May it please, Your Lordship. May it please, Your Lordship. Lordship, I beg to mention item number 14.
Yes.
Hearings, please. Lordship, kindly list the matter after 2 weeks since my senior is indisposed.
Okay, Mr.
No more on behalf of
Learned
Nuksum
Counsel
Tila.
appearing on behalf of Nuksum Tila.
Yes.
Learned Counsel for the petitioner has submitted that MS or Mr.
No more on behalf of Nuksum Tila.
Nuksum Sila is indisposed and has thus prayed for listing of the case after
2 weeks, yeah.
2 weeks. MS Livika, Learned State Council for the respondents is in attendance. The prayer is allowed, is the case after 2 weeks.
Obliged, Lordship.
Yeah, please, Your Lordship. May we please to mention item number 7. Item 7, Your Lordship.
Yes,
Your Lordship, let the matter come up after a week, Your Lordship.
I think
I'm yet
habeas
to fi-
corpus.
Yes, it's in the habeas corpus, Your Lordship. The petition was amended and like I have sent the amended copy, Your Lordship. So a week time and within
Okay.
that time I'll find my affidavit, Your Lordship.
MS, Learned counsel for the petition is present. MS Livika, Learned State Council, has submitted that she is yet to receive the necessary instructions pursuant to the amended writ petition. And she has prayed for a week's time to obtain the instructions and to file counter affidavit in opposition on behalf of the state respondents. The prayer made by MS Livika stands allowed to release the case after a week.
Much obliged.
Lordships, I beg to mention hearing item number 27.
27, yes.
Yes, Lordship, here I have a humble prayer. On the last occasion, we have made a submission that the petitioners are of the considered opinion to withdraw the case. So do they have the instruction to withdraw this case? So I may be allowed to withdraw this case.
Okay, Mr.
Ali was Lordship.
Aliba Ojuku,
Yes, ma'am.
Learned counsel for the petition, Learned counsel for the appellants,
Appellants.
has submitted comma on instruction, comma that the appellants do not want to pursue the writ appeal. Full stop. Yes, Mr. State Counsel, Mr. Im Chong, Learned Additional Advocate General, Nagaland, for the respondent number 1, 2, and 3. Mr. R. Iralo, Learned Senior Counsel, assisted by Mr. Learned Counsel for the respondent number 4. And Mr. N. Learned Counsel for the respondent number 5 are present. Full stop. In view of the above submission made by Mr. Ali Ojukum, Learned Counsel for the appellants, comma, the writ appeal stands dismissed on withdrawal.
Lordships.
Please, my lords.
Yes.
Lordship, item number 6.
6.
Yes, on behalf of MS Meret. May it be-
6 already mentioned.
No, sorry, item number 9, I'm sorry. Item number 9. May it be listed,
NSA,
yes, Lordship.
yes,
Yes,
yes.
may it be listed next week, Lordship. She has indicated
You are appearing on behalf of?
MS S Meret.
Okay. MS
Mika, Lordship.
Mika, Learned Counsel for the petitioner is present. Mr. Ki Angami, Learned State Counsel, appearing for MS S Mere, Learned State Counsel, representing the state respondents, has sought for listing of the case in the next week on the ground that Ms. Mere has some personal difficulty today. Post up. As the prayer is not objected to by Ms. So-and-so Learned Counsel appearing for the petitioner, the prayer is allowed, leaves the case in the next week.
Lordship. Lordship, item 10.
Yes,
This also may be listed next week. Lordship.
next week. Yes, where is the petition counsel? Yes. Yes, so-and-so Learned Counsel for the petition is present on the prayer of Mr. Kiangami, Learned State Counsel. The appeal stands adjourned for a week.
Lordship. And Lordship, item number 12 and 13. Lordship.
Yes,
Lordship, may it be listed after 3 weeks, Lordship. I've taken the consent of the
criminal appeal. Yes, Mr.
W. Master Lordship, in criminal 6 of 2020, I'm the appellant, my lordship, and I don't know what's your.
Okay, who is the counsel jail appeal?
Your Lordship, I'm for the appellant in criminal number 4,
Okay, your name please.
Limika Kinimi, on behalf of me too.
Okay, MS Mr. W. Maru, Learned Counsel for the appellant in item 12. And MS so-and-so, Learned Counsel representing Mr. Neetu Koja in item number 30. Are present. And Mr. Kiangami, Learned Public Prosecutor. Has, yes, you want
3 weeks, Lordship.
Learned Public Prosecutor has prayed for listing of the appeals after 2 weeks. The Learned Counsel preparing for the appellants have expressed no objection to the said prayer. Post of the prayer is allowed in the case, at least the appeals after 3 weeks.
My lord. May I please, your lordships, I beg to mention hearing item 16 to 24.
16 to 24.
Yes, your lordship.
Okay,
I plead this matter may be listed after 2 weeks.
you are for state or you are for private?
I'm for this.
Yes, Mr. Tivapam.
No objection, my lord.
Okay, Mr. Tivapam, learned counsel for the state of Nagaland. Learned government advocate,
No, government advocate.
government advocate
Yes, ma'am.
for the state of Nagaland. Is present, Mr.
Benison Bishop.
Benison V. Shohei. Learned counsel has submitted that he has entered appearance on behalf of the sole respondent in each of the appeals. You are appearing in all
Yes, your lordship.
for the sole respondent in each of the writ appeals. First of, he has paid for listing of the appeals after
2 weeks.
2 weeks. First of, as the prayer is not objected to Mr. by Tivapam, Nagaland State Council, let the cases appeals be listed after 3 weeks. 3 weeks.
2 weeks.
2 weeks.
Much more.
Promotion, item number 1.
My please, Lordship. Lordship, here the leading counsel, Nipendra Roy, is from Kolkata, Lordship. Lordship, he is having some difficulties in connecting with the PC link. So I pray that the matter may be taken up at 2, Your Lordship.
By the time list might exhaust,
Lordship, so after the listed item.
after the matters are called
Yes,
up.
yes, Lordship. Yeah. Obliged, ma'am.
For admission, item number 2.
Lordship. An opinion was expressed by this honorable court that I must file a comprehensive affidavit indicating the progress of the work and because there are so many affidavits which has been filed.
It has become bulky.
Yes, Lordship. So I have filed that affidavit on 5th of September 2023, my lord.
Tell me at first, what is the subject matter?
Lordship, this is for construction of road, Lordship. Now, 3 work orders were issued, one amounting to 569 lakhs, another amounting to 3,000 lakhs, another amounting to 2,677 lakhs.
Construction of 3 roads.
Construction of 3 roads, Lordship.
Ah.
Now, this in 2 work projects, Lordship. Completion certificate was issued way back in 2014 without the work being done by the respondent number 5. This honorable court has directed for taking action against the respondent number 5 and submitting action taken report before this honorable court, which exercise has already been completed. The department has taken action against the concerned executive engineer who issued the completion certificate. Now, Lordship, the fact remains that despite the lapse of time, no work has been done, Lordship. Now, again, another work order was issued. That is the 3rd work order, Lordship, amounting to
2,677 lakhs, that is 26 crores and 77 lakhs, Lordship. Now, for under the PMGSY scheme. Now, Lordship, that work they have done to a certain extent, Lordship. However, presently, there is no machinery at site. Not a single manpower on site. In short, it has been few months now, Lordship. They have abandoned the work.
Who, new contractor or old
The
contractor?
old contract, because Lordship.
Same man was given the same contract again,
Yes,
contractor.
Lordship.
Contract.
The work order was issued to another firm, Lordship, but the work has been executed by the same contractor who executed the previous two works, because he is the attorney holder of the third work order, Lordship. That fact is not in dispute. They have also filed affidavit regarding that, Lordship.
No,
Now-
today it has come for what?
My Lordship, humble prayer before this honorable court is that, Lordship, direction may be given so that the roads are constructed by the respondent number 7, by the contractor. The BIL has been filed in 2020. Committee was also appointed by this honorable court to go and inspect the roads, the 3 roads, Lordship. That committee, Lordship, has also filed a report, site inspection report on 26th of November 2022.
1 minute. Who are the litigants? PIL litigants? Old. In what capacity they are filing this PIL?
Lordship,
Residents or what?
yes, they are residents of that area. Lordship, it's a big area, Lordship. In fact, the area borders Burma, Myanmar, Lordship.
Okay, let us see the first PIL petition.
PIL
Let us
Lordship,
understand, let us understand.
It was filed on 10th of November 2020.
That main PIL,
Yes, main PIL.
let us see. PIL, what is PIL? So many pleadings. So many pleadings. This is additional repetition or not? Additional repetition. Additional. This is what. Repeat it. Repeat it. Repeat it. This is the piano. What is the prayer in the PL? Let us see.
To set up an inquiry committee, Lordship, under the supervision of this honorable court, to inquire, investigate into the utilization or misutilization of the funds for construction of roads from Lepori to Moli and the Black District. White work order so and so, Lordship. And 2 is to direct the respondents for construction and maintenance of good proper roads from Lepori to Moli.
The petitioners are respondents of that area. Petitioners are residents of that area or what?
Yes, my lord,
Hmm?
all of them.
Okay, where is the work order?
The work order, Lordship.
Work order was issued when?
The work order is annexed at. Work order was issued in 2011, Lordship. So it is annexed by the respondent number 7 in his affidavit in opposition filed on 7th of April 2022, Lordship. At Annexure A, page 12. The second work order is annexed at Annexure P, page 15 of that same affidavit, Lordship.
No, I am looking at your PIL
Yes,
petition.
yes, Lordship. In my PIL, Lordship, I have enclosed the working estimate.
This additional 15 crores
Yes, Lordship.
is in connection with the same work. or
Yes,
what?
yes, Lordship. And Lordship,
Huh?
yes. And Lordship, all the roads, they overlap one another.
Construction of road from Lepori to Malhe Post. Right.
Yes, Lordship.
Work order was issued in 2011.
Yes. And completion certificate was issued in the year 2014.
Then what about this additional fund?
Additional fund, Lordship, it was issued. Now, after the completion certificate was issued, additional fund was made available in 2017, Lordship, 15 crores.
For the same road?
Yes, for the same road. Here, the amount is 30 crores, Lordship. So
For,
it is
for what purpose? That second 15 crores?
for perhaps for execution of the construction work of the roads. It is clearly mentioned, Lordship, in the body of the letter. And the following year also, in 2018 also, another additional 15 crores was sanctioned. Now we are not on why so much money has been sanctioned, Lordship. We just want good basic roads to be constructed in our area when so much money has been made available by the state government.
So when you filed a PIL,
Yes, Lordship.
what was the response from the state respondent as regards this allotment of fund? 30 crores plus 15 crores? What did they say?
Lordship, on that, the respondent number 7, they have filed an affidavit that
Who is respondent number 7?
the contractor, Lordship, saying that they have withdrawn 4.84 crores for one project and another 26.54 crore in another project.
Who is the affidavit of the respondent number? Between opposition.
It was filed on April by Lordship on 14th of June 2022.
One is 6th April 2022.
Yes, Lordship.
What is that? What did he say?
The state respondents also have filed an affidavit on.
Let us see his affidavit. Respondent number 7 affidavit first.
It was filed on 14th of June 2022.
One is 6th April 2022. Respondent number 7.
Here at page 3, Lordship, paragraph 5, they have categorically mentioned the amount that was received by them, Lordship. If I may read it, Lordship.
1 minute. What kind of road? It is concrete road or what? What was contemplated
Lordship,
as part of
Looking
work
road
order?
for the road under PMCSY scheme. It is GSP and all this has to be now had to be led, Lordship. Now for the other two projects, Lordship.
Let us go one by one. I know, I have not understood that fully. Let us start from the beginning
My lord,
to understand
my lord.
what is your case.
Yes, Lord.
So that is what I am trying to do.
Yes, Lord.
I cannot catch hold of in the middle and
Yes, yes, my lord.
without understanding the basic case.
Yes, my lord.
Come to his page 12 of his affidavit in opposition.
My lord, dated
Dated 6th April 2022.
Yes, Lord.
That work order you will find at page 15.
Yes, Lord. The second work order, Lord.
Hmm.
The first work order is attached to your Lordship.
Then come to page 16.
Yes.
First one is site clearance.
Yes, Lordship. Here. Here.
Right. Next is artwork.
Yes, Lordship.
Third is side drain.
Yes, Lordship.
4 is construction of subgrade and hardened
Yes, Lordship.
soldier.
Yes.
5 road
Here,
composition WBM.
Yes.
7 cross drainage work.
Yes.
8 protection work.
Yes,
Right?
Lordship. Yes, Lordship.
So next page, come to next page. Executive engineer, he
Yes.
said about status report of 2018.
Yeah.
Artwork in formation cutting,
Yes.
5 kilometer remaining.
Yes, Lordship.
WBM work completed for 20 kilometer. It is not done.
No, it is not done. It is not done.
Side drain completed for 20 kilometer. CD and protection work
Yes.
yet to start. CD means cross drainage works,
Yes.
and item number 7 and 8 not completed.
Yes, Lordship.
According to this executive engineer certificate, 1 to 5 might have been completed. At least for 20 kilometers.
Yes, Lordship. But
Huh?
Lordship, after
That is certificate,
yes, Lordship.
and pictures are there
Yes.
from the next page,
Yes, Lordship.
right?
Yes.
Okay,
Now-
for doing this work, how much he has
So-
taken from the department? You are concerned with which road?
Lordship, all these roads.
Lepori to
Yes.
Molhe.
No, Lordship. After this also, another work order was issued, Lordship. In the same.
Oh, let us go by one. Why?
Yes.
Let us understand
Yes.
your case.
Yes. So.
You are concerned with which road?
Yes.
Lepori to Molhe.
Yes, Lepori to Mole.
Till that, so that there are other documents
Yes.
pertaining to other road,
Yes, yes.
right?
Yes.
There are documents akin to Star Lake also.
Yes, Lordship.
So we will not see that. Yes, what is the stand of the state respondent?
May it please your lordships.
Yes, Mr. Sankar.
Your lordship, if I may be allowed to read my state respondents affidavit, there are three running page 2.
State respondent affidavit.
Particularly, there are three running page 3B, your lordship.
1 minute, let me locate
Yes, your lordship.
your affidavit. Respondent number 1 to 5,
Yes, your lordship. 1, 2, 3,
filed
4, and
on
5.
16 March 2022.
Yes, your lordship.
Okay. Paragraph
There are three running page 3B, your lordship.
B.
May I read, your lordship?
Hmm.
That the project for construction of road from Lipori to Molhe Camp and Aken to Star Lake are ongoing project and not cross public roads, as alleged by the petitioner. As per record, the executive engineer PWT RNP PEC division submitted status report dated 22/11/2018 to the chief engineer PWT RNP Kohima Nagaland as regards the progress of the construction of road from Lipori to Molhe Post. As construction of road from Aken to Star Lake, as per the progress report dated 2011/2021, submitted by the executive engineer PWT RNP PEC division to the chief engineer PWT RNP Kohima Nagaland, 95% of the road has been completed. Therefore, the contention of the petitioner that the construction of road from Lipori to Molhe Camp and Aken to Star Lake against coast public road is denied. See that the both roads are ongoing. The delay for completion of the instant project is due to several reasons. However, the department is giving utmost priority to complete the work at the earliest, and the contractor is also directed to do the needful without fail. And my lords,
Hmm.
I may be allowed to read. There are six running page 10, your lordship.
Yes.
That with regard to the statements made in para 9, 10, 11, 12, and 13, the deponent reiterates and reaffirms the statements made in para 3, clause A to G of this affidavit. The construction of road from Lipori to Molhe Post and construction of road from Aken to Star Lake is still ongoing, and all efforts are being made to complete the same at the earliest.
What about the show cause notice?
Action taken, your lordship.
Show cause notice, the next line. Next line, page 11. What is this show cause notice?
It may be mentioned that in regard to the issuance of completion certificate by the concerned executive engineer, the chief engineer PWT RNP has issued a show cause notice dated 23/2014, and a reply dated 24/3/2014 is also received.
Let us see that.
An action has already been initiated, your lordship, against the executive engineer of the concerned division.
That is at page 34.
Yes, your lordships. May I read, your lordships? Government of Nagaland, Office of the Chief Engineer, PWT RNP, Nagaland, Kohima, number such and such, dated Kohima, 20th March 2014. Show cause notice. Whereas in pursuance to work order number such and such, dated 20 November 2011, with regard to construction of road from Lipori to Molhe Camp, this show cause notice is served to you
as it has come to the notice of the undersigned that you have issued completion report to the ongoing work before work completion is in violation of the government standing rules.
So after filing of this counter affidavit, what is the progress? What is the progress?
Your lordship, running page 35, annexure N is
That
the
is his
reply.
reply. We are more concerned with the roads construction work. He has issued some completion certificate. Then what is the next development progress?
I'm yet to receive the latest status report, your lordship.
Hmm?
And if I may
What
be
is your,
allowed,
what is your reply, Mr.?
your lordships, if I
Sandy
may be
Anger?
allowed to
Ah.
serve this latest status report.
Lordship,
What
After-
is your reply to those affidavits by the
Yes.
respondents?
Lordship, after this affidavit was filed, a committee was appointed by this honorable court to inspect the progress of the work, Lordship. And the statements that they have made before this honorable court by way of this affidavit, Lordship, it has been belied, Lordship, by the findings of the committee, Lordship. The report is placed on the report of this honorable court, Lordship, on
Right.
16th of November. A four-man committee report was appointed by this honorable court.
By which order that was inquiry committee was? By which order? It appears that, yes, so many orders. I think
Yes, Lordship.
we are very new to this
Yes.
litigation.
Yes.
None of us has taken up, so we are at a bit of a loss. Because one particular branch was taking up this matter. And so they are in know-how of what is going on day to day.
Yes, the Lordship permits me to say a few
Mr.
words.
Santiago,
Yes.
that is the difficulty,
Yes,
because
Lordship.
both of us
Yes. In that case,
have seen this for the first time.
yes,
And this orders, it is this bulky.
yes, Lordship, in that case, if it can be adjourned,
So it is
No.
very difficult to
yes,
understand what is going on. So many pleadings.
yes.
Yes, Mr. Joe.
My lord. Yes, my lord, I represent R7 contractor. Earlier, this case was handled by one of my colleagues, but now the brief has come to me. I have interference on 10th October this year. This is November. My lord, Lordship knows very well about the nature of PI. This, I have raised serious objection on maintainability of this PI. These PIs cannot be maintained at all cost. Why? Because Lordship is aware. Now, Supreme Court, because of so many frivolous petitions in the nature of PIL filed in India, Supreme Court, in the case of Uttaranchal versus Balwant Singh Chawla, had passed the judgment on 18/1/2010 and passed the guideline how to follow all over the country. Based on the Supreme Court judgment in this case, this Honorable High Court, Gauhati High Court, has made the rule under Article 225 of the Constitution of India, following the guideline laid down by the apex court, as I have mentioned. There, the guideline is very simple, and the present PIL petitioners conveniently avoided the procedure because they have guilty feeling. They have the guilty feeling. I will explain. I have filed pleading no objection. And as per Supreme judgment, before entering the merit of the case, if anybody has filed pleading objection, that should be heard first. Now, the Gauhati High Court Rule 2011 Lordship, I don't. This petition is fit to be dismissed today. These are the High Court rules, my lord. These rules have been framed based on Supreme Court judgment.
Okay, 1 minute. Let me have the, go through the instruction.
High Court Rule 2011, Part 3. Part 3, my lord, Part 3.
Just a minute, Mr.
My lord.
So as per the new status report, this Lepori Mole Camp Road, that is, progress is 75%.
No, Lordship. Lordship, no, that is not.
You're saying no, our saying no, these are all works
Yes,
at the field level. By
Lordship,
which order expert committee was,
order dated,
Mr. Joe will hear you. Let us understand first. Why this
by
has been
order
taken.
dated 1st November 2022, Lordship, last year.
Hmm.
1st November 2022. The committee was constituted by this honorable court.
October 2023 latest report, not 2022. This is 2023.
Why this committee has been constituted, let me find out. Who is respondent number 11? Mr. Santiago, who is
The
respondent?
executive engineer was directed to be included in person, Lordship. The respondent number 5. The person who issued the completion certificate.
What happened thereafter? Committee visited.
Yes, committee visited on 10 and 11 of November 2022, Lordship, and the report was submitted on 16th.
What did it say?
It says that, Lordship, at paragraph 7, Lordship, a table has been given. So
It is an advocate of a commission or committee of advocates,
yes, Lordship.
right?
Yes, Lord.
To understand what kind of progress
Yes,
has been
Lordship.
made.
Yes, Lord.
You go to the decision in MK Jose,
Lordship.
Supreme Court.
Lordship.
Supreme Court appointed a committee of advocates to find out the progress. High Court. Supreme Court has come down heavily. This is a concept alien to writ proceeding. How can the High Court appoint a committee of advocates to find out progress of a contract work?
Lordship.
It can be done,
Yes.
but still there was an observation that it can be done in PIL.
Yes.
But question is about deprivation.
Yes.
Whether it is a case of deprivation. Find out that MK Joe judgment also. But so far, there has to be experts. Advocates are not experts.
Yes, Lord.
May I please, Lordship?
How can we take, what is the sum and substance of the advocate committee report?
That in
Sum and substance. How much progress?
now, no progress, Lordship.
No progress.
Yes, Lordship.
Where is the report?
Lordship. On behalf of the citizen. My Lord, what mechanic to the government, we must not help as well.
Yes.
So, in all the cases of law, we have engaged private counsels. And my name has been reflected in the cost list. So I pray that my name may be directed on the cost list as a CCC. Because the more we are engaging private, instead of engaging the single government council, we are engaging private councils, the ministry of more. That is why my name may be elected.
Now, whether MORTH is a party respondent in this?
Yes, but.
Huh?
What? When to do? There are more than 10 cases.
Now, who
Yes.
represents respondent number 6? Used to represent or what?
I used to represent, but in the other cases, we have already engaged private counsels.
Now,
Yeah.
in this case,
In this case, no one has been engaged. My
then
name
how
has been-
can,
My name has been entered in the Bagarat Amran, in the cost list.
but how can you say that you were not permitted to appear?
Lordship, I have already written to them. I have already forwarded the petition, but there is no response from the ministry. And as such, I will not be able to defend the case. There is no instruction so far. And there are more than 10 cases, similar cases, that is filed against the Ministry of Road Transport. And in all those other cases, private counsels have been engaged.
I think Mr. Joe,
My lord.
it would be better if the bench who is looking after this PL should take up this, because On the first, it will be difficult to understand all the proceedings.
Otherwise, I have raised no objection.
No.
It's a fit case to be dismissed.
Okay, your preliminary issue of maintainability will be left open for consideration. On the next day. Okay, you be there on the next day, the regular bench will consider your application. I'll take note of it.
Lordship, in the meantime, I may be allowed to make a reply to the affidavit filed by the respondent number 7, the latest affidavit, which was received by me on 10th of October 2023.
Mr. Mr. Santiago,
My lord.
learned counsel for the petitioners. Mr. Sankam, learned additional advocate general. Nagaland for the respondent number 1, 2,
Assisted by V. Zimomi.
assisted by P. Jimomi, learned state council for the respondent number 1, 2, 3, 4, 5. Mr. Wangarwati, learned central government council for the respondent number 6. Mr. Ajo, learned council
R7.
for the respondent number 7. 8, 9, 10, 11, anybody? Joseko Forte, learned council for the respondent number 11. Heard. Anybody representing 8, 9, 10? Kamalia Area Public Organization, Aken Village. Those two. What was the last one?
So, former respondent, Lordship.
On the previous date, Mr. Santiago, there was a prayer to
Yes.
go through the affidavit in opposition and to file an affidavit in reply.
My lord, my lord.
So, Mr. Sankam, today the papers you have placed, whether they were part of that affidavit in opposition.
Yes, Your Lordship, but I may be allowed to file additional affidavit.
I think
About
this is
the
the progress
status
now,
report,
at
maybe.
least some scientifically they have made a table. This one,
Yes, Lord.
today's
Yes,
16th October,
yes, my lord.
Yes, Lordship.
do you have a copy of it? This?
I did not receive.
This is all state respondents' paper.
So let him file,
Yes,
and
Lordship.
you can file a consolidated reply.
Yes, Lordship. And in the meantime, I may be also furnish a copy, Lordship.
No, he'll bring this by way of an affidavit,
My lord, my lord, my lord.
right?
My lord.
Then you can file a consolidated reply affidavit,
Yes, Lordship.
right? But work is going on or not, Mr. Joe?
Little more than 70 people are on the job. According to the information this morning.
Lordship,
Whether PIL is maintainable or not maintainable, that is another issue, but you must continue with the work.
yes, Lordship. That is our only prayer
Your
before this
client.
honorable court.
Mr. Sankam Lanet. Additional.
Yes, in fact, I request my latest senior counsel to do some fact checking, Lordship.
Mr. Joe should visit the place also,
My lord, I'm an expert, that's the problem.
but with your normal eyes, you can find out how much progress.
This morning, yes. I've got an instruction.
Has submitted that right communication by the communication dated 16th October 2023. Comma. He has received pairwise comments in respect of the additional affidavit filed by the petitioner. Full stop. As the communication, pairwise comments contain up-to-date status report as regards the progress made in respect of construction of those works, which are at issue in this PL, you would like to bring the same by way of an affidavit in opposition to the additional affidavit filed on behalf of the petition. He, 1 week?
Yeah, 2 weeks then.
2 weeks. He has sought for 2 weeks' time to file such affidavit in opposition. Mr. Santiago has on the other hand, submitted that he will file an affidavit in reply, a consolidated affidavit in reply to an earlier affidavit in opposition filed by the state respondents, and the affidavit in opposition to be filed, as submitted by Mr. Santa. Within 2 weeks thereafter. Within 2 weeks after filing of such affidavit. Then after vacation.
My lord, let us take a chance.
You continue with your work. You are not hampered. Mr. A. Joe, Mr. Joe, learned counsel for the petition, appearing for the petitioner, has however raised the point of maintainability of such PL on issues I raised herein. Mr. Vengarvati, learned Central Government Council, appearing for the respondent number 6, has submitted that he has already written to the concerned ministry, i.e., the Ministry of Road Transport and Highways, Government of India, on 28/8/2023, informing that he would no longer be appearing on behalf of the MORTH in this PL. In response to, it appears, in response to the state communication dated 28/8/2000, he has thus paid for deletion of his name from the cause lists. He has, however, fairly submitted that in response to the letter dated 28/8/2023, the ministry has not, the MORTH has not yet engaged any new counsel to represent the respondent number 3. Six. The request made by Mr. Vangarvati, learned CGC, is left for consideration on the next date of listing. Similarly, the issue raised by Mr. Joe is kept open for consideration on the next date. Is left for consideration on a preliminary issue raised by Mr. Joe, and a counsel for the respondent is left for consideration on the next date of listing. As agreed to by the learned counsel for the parties. After 4 weeks. Agreed? Which date?
Can it be on 6, my lord?
This 6. He is filing within 2 weeks. He has paid for 2 weeks time.
Before that.
Mr. Sentianger has paid for further 2 weeks time.
Yes. So,
So he cannot be on 6th.
yes, on 13, Lordship.
I have criminal case in Kohima. So I have a problem with it. In that case, next year.
Next year only.
Lordship, let's take a chance on 12, Lordship, because
4 years will expire by that time. 4 weeks. But there will be 4 weeks. If Mr. Sankam can cut short to 1 week, then I can fix. If 1 week for
A
filing
week's
of
time.
affidavit, then
A week's time may be granted, Your Lordship.
okay, today is
Lordship, then in that case, let us try on 6th.
okay, leave that part of Santiago filing of affidavit. Release the case on 11.
My lord, highly obliged.
Leave that part. Your prayer about submitting affidavit, I have
My lord,
deleted.
my lord,
Let him file
my lord,
within 1 week
my lord.
or 10 days. 10 days, that will do. 10 days.
Highly obliged, my lord.
My lord. Item number 3.
Yeah. Yes, I mean, Supreme.
Please, Lordship.
Yes.
Lordships, here the respondents have not yet filed their affidavits.
Yes, I'm a Supreme.
This PIL, it has become infructuous because by order dated 22/9/2021.
22/9/2021.
21. Yes, this court has directed the PIL to be listed after the disposal of writ petition number 52 of 2020 and writ petition number 93 of 2021. So, Your Lordship, this writ petition, the single judge, he has dismissed the writ petition. So against which the petitioner, he approached the division bench. In the division bench also, the honorable division bench has upheld the single judge. Thereafter, the petitioner, they approached the Supreme Court filing an SLP, but it has been withdrawn. That is what I've been informed. So now the writ petition has become infructuous.
Lordship, may I clarify?
The PIL.
By order dated 14/9/2022, Lordship. Because
1
the
minute, what is the PIL about?
Lordship, the PIL and the writ appeal is
Huh?
is a different subject, Lordship.
1 minute.
Because the writ appeal was challenging the approval of
Wait.
tender,
PIL.
approval of tender to the contractor.
One.
Here, the PIL is concerning the execution of work.
Lordship, page
Lordship.
18, that is the prayer of the PIL. page
Lordship, may
18.
kindly see order dated 14/9/2022, Lordship.
Page 18, the prayer is to issue a writ in nature of mandamus or any other appropriate writ or direction, thereby directing the respondent to immediately execute, implement the project.
Now, who
heading
is
to
this
the-
PIL petitioner?
Yes,
Social worker. social worker.
My lord, we kindly see order dated 14/9/2022.
We'll see, let us see the prayer, then I can understand. Directly respond to immediately execute or implement the project. Training to Lekki Road in Nagaland for sanction under so and so. We should the period of completion. Make up for the time.
So Lordship, again come to page 7, their statement at para 13. Page 7, para 13.
Page 7 of the PL.
Yes, page 7, paragraph 13.
Yes.
The respondent number 4, by its letter dated 13 November 2020, gave a callous reply to the Zuni Students Union that after completing the tender process, the work pertaining the Lekki Road project has already been allotted to MS Nagami Infratech. However, the decision of the department is under challenge by MS High Tech Construction and Co. by filing a writ petition before the High Court, for which the matter is subjected to the outcome of the court case. So, Your Lordship, the work was allotted to MS Nagami Infratech, against which MS High Tech Construction filed the writ petition. So the writ petition was dismissed. So he filed an appeal. The appeal was also dismissed. So MS High Tech Construction filed an SLP in the Supreme Court, and he withdrew that SLP. So now the project is will be executed by MS Nagami Infratech. And the only prayer of the
It is
petitioner-
executed by that Nagami Infratech.
Yes.
So any interim order was operating at that point of time in
No,
the
lordship.
No,
writ petitions,
Lordship,
in the writ petitions.
in the writ petitions.
no, no
Yes,
interim.
interim was there, interim was there. Yes, interim was there.
So that in the writ petitions,
Yes,
ultimately interim order was recalled, perhaps,
yes,
with the dismissal of the writ petition.
yes. Thereafter, the,
Considered being devoid of merit, accordingly stands dismissed. Nothing survives. Interim order was operating.
yes,
Then those writ petitions were dismissed on 16/3/2022.
Lordship, I don't have the exact, my apology, Lordship, yes.
16/3/2022.
Yes,
That was by High Tech. Then thereafter, the writ appeal was dismissed on 21/7/2022. Then that was regarding award of work
yes, to
and
Nagami.
by one contractor again, by one bidder against another
Yes,
bidder.
another
Yes,
bidder,
Lordship.
Right?
Yes.
So ultimately that proceeding ended before the division bench on 21/7/2022.
22, yes,
Then thereafter
file-
SLP.
yes, the final.
So that was a fight between two tenderers,
Yes,
Yes, lordship.
right?
yes, Lordship,
Two
So
bidders. One
that
was
cannot be
successful,
confused,
the
Lordship.
other was unsuccessful.
yes,
Now, after award of the work
Mm.
in favor of high-tech construction,
not in favor of High Tech, in favor of
or
Nagami.
Taman
Yes, yes,
the successful bidder.
yes,
Yes, Lord.
So basically, his job is to execute the work.
Yes, lordship.
And this, with PIL petitioner is interested that this work should be
yes,
executed.
Yes.
yes.
So
So now,
Lordship, now
You
the,
take a progress report,
Lordship,
Yes,
I
Lordship.
can do, yes. I can
progress
do-
report.
Yes, I can do that.
yes, apparently lordship, the, after the
Might be
After
seen,
the
Mr. Council, after.
order was upheld, lordship.
After the award of the work
Yes,
order,
lordship.
if some interim order was operating,
Yes,
that contractor was not able to undertake the work, right?
yes,
If
lordship.
interim order was operating, if
Yes,
ultimately that writ proceeding ended in first part of 2022. Writ appeal ended in second part of 2022.
yes,
Thereafter SLP, I don't know when SLP was withdrawn.
Yes.
So after that, he got the sigh of relief, the successful
Yes.
bidder.
yes, lordship.
Only after that he would undertake. Suppose he
Yes.
would not undertake if the interim order is operating, or otherwise also, why he should undertake after executing 10%, 20%, if his work order is cancelled, he will be nowhere. Is it
Yes,
not?
lordship, that Exactly,
Now,
that is
question
reflected
is,
in order
your
14.
interest is
Yes, Lordship.
that road should be constructed.
Yes, yes, Lordship. And also
That is
to
your
monitor.
limit, unless you have any other hidden agenda,
Yes, Lordship.
right?
Because
So,
Lordship,
let us
this
have
was,
progress report.
this was taken up and the order is reflected in 14/9/2022, Lordship.
What? 14.
Exactly, because it was upheld and therefore I was directed to implement respondent number 5, which is
Have you
the
implemented?
incumbent contractor, Lordship.
Huh?
Now
14,
I've met
14/9?
necessary, I've taken necessary steps and I've implemented the contractor, which is respondent number 5, Lordship.
Respondent number 5
Yes, Lordship.
in the PIL.
Yes. And also I've served
By
notice
which
to-
order? 1/3/2023. By which order he has been implemented? I
1/3/23.
by Lordship,
notices,
it is
notices
reflected
has
in
gone or not?
26/4/2023. Lordship, and I was directed to serve the
By way of Dusty also.
by way of this.
Did you submit?
Yes, Lordship, and I've also filed the affidavit for proof of service, Lordship.
Has
Now
filed a
the
affidavit
respondent number
showing
5
service of notice raised to
has not
verify
shown appearance.
and place the same on record. Now we have to examine that affidavit.
Yes.
Why
Lordship.
don't you, at the very beginning,
Lordship, here, if state can file their
One
affidavit,
minute.
Lordship.
this
Showing the progress report.
now whether this respondent number 5 has entered or not. Appearance, anybody has
No,
entered?
Lordship. Tim, no, not.
Who is this? Mr. Counsel, this kind of dusty affidavit, only signature,
Lordship.
neither seal nor name. How can we accept this?
They've accepted, Lordship.
Who has?
The contractor.
Who is this man?
Lordship, I don't have the copy with me now.
Check and tell
That's-
me.
Yes, Lordship.
Check and tell me. By legal consultant of respondent number 5, neither his name nor any seal. This kind of affidavit cannot be accepted. Check yourself. That will be not acceptable.
Lordship, then in that case, let me take fresh step.
Take steps, get the
Yes.
seal, if it is a company, get the seal or the name of the person.
Yes, Lordship. Because,
Somebody does it.
yes, it
Court
was
will
done
not
by
accept.
their legal consultant, but
Who is the legal consultant?
yes, Lordship.
Who is? Tell me the name. If Mr. Santiago is the legal consultant, we'll ask him.
Allow me to file, take fresh step, Lordship.
Better. You mean the, Ms. Sukri, you
Yes.
mean that have a progress report.
Lordship.
Heard, Mr. Nito Koja.
Lordship, K. Arka, on behalf of MS Nityokoza.
Oh, your name is not there.
Yes, Lordship.
Representing Mr. Nito Koja.
MS,
Representing the petition and MS P. Sukri, Lion Edition, Advocate General. Nagaland, for the respondent number 1 to 4.
Oh, no, 3 and 4.
Oh, for the respondent number 3 and 4. None has appeared. For the respondent number 1 and the respondent number 2. Today on the call. Yes. Earlier, who accepted notice? Who accepted notice for respondent number 1 and 2? Is the council? In Koja. Centrally sponsored.
Yes, Your Lordship, from under donor.
Oh, no, chief is not available. No, chief is not available. Mr. Council, service of notice upon the respondent number 1 and the respondent number 2 are also not affected. Not served.
Lordship, it was served through registered
The
agent.
registered post service report not available.
In that case, fresh steps.
You
I
take
should
three
take
steps,
first step,
1,
Lordship.
2, and 5. And if you want to take by way of dusty upon respondent number 5,
Lordship,
take it in a better manner. First, the petitioner has filed an affidavit. As regards service of notice upon the respondent number 5 by way of the state. On perusal of the receipt copy of the notice, comma, it appears that the person who had received the notice on behalf of the name of the person who had received the notice on behalf of the respondent of 5 is not reflected, nor any seal of the respondent of 5. Who is a private limited company, comma, is found available in the said receipt. So in such situation, fact situation, comma, this court is not in a position to accept that the notice has been duly affected upon the respondent of 5 by way of the state. Mr. Swain's Land Council for the from the notes it does not transpire that the notices of which were sent to the respondent number 1 and the respondent number 2 by way of registered post comma have been duly served. Mr. Swain's Land Council for the petitioner has submitted that he may be permitted to take steps for service of notice on the respondent number 1, comma, respondent number 2, and the respondent number 5 by the petitioner shall take 3 steps for service of notice upon the respondent number 1, 2, and 5 by way of registered post with AD within 3 working days. Dusty?
Lordship, for respondent number 5, Dusty.
as requested, the petitioner is permitted, as paid for, the petitioner is permitted to take steps for service of notice, press steps for service of notice. Upon the response number 5 by way of the stick, which should be routed to the registry. And after effecting service of notice by way of the stay upon the response of 5, the petitioner shall file a compliance affidavit to that effect within 3 weeks. This is the case after 4 weeks, 3 weeks. In the meantime, MS Supreme and revision AD shall obtain a progress report, status report as regards the construction work of the road. What road? Turning to Lekki Road.
Item number 4.
Reconstruction.
Please, my lord, this is the case where,
That 20 years is not
yes,
as
yes,
long.
my lord, I have,
To admit, put you.
if I may be allowed to place the citation.
Which one? That one?
Yes, my lord,
But that is at the end, but that is not the law.
yes, lord.
20 years is not the law. That ultimately in the judgment, he has been punished for, convicted for 20 years, sentenced for 20 years.
Yes, lord.
But that is not the law. I thought that somebody was discussing that decision. But that is not the law. Law means life means life.
Yes, lord.
Then we will ask the registry to prepare the paperwork.
My lord. Otherwise, I'm ready to take up the matter, lordship. My
You
lord.
have to admit this. It is
It
not
has
yet
already been,
admitted.
it has been admitted, lordship.
Yes.
It has been admitted by order dated 22/3/2023.
Mr. Sandianger,
Yes, my lord.
let this paperwork be prepared.
Lordship, lordship.
Yes, otherwise, maybe
Yes. Here, my
already
lord.
20 years.
Yes, my lord. I have no, I bow to the wisdom of this honorable court, my lord, it's all right if the paper books are prepared, lordship, but
Mr. Angami, otherwise, how long the registry takes to prepare the paperwork? It will not be bulky.
no, but
Some handwritten things are there.
yes, yes, but it will be posted to next year, lordship, probably, in all probability, lordship, because it takes some time, lordship. In other cases also,
Huh?
3 months
Huh?
stretch minimum.
We can try to restrict it within, preferably within 2 weeks.
Yes. Yes.
Let us have a try so that it can be expedited. You are legal aid counsel,
yes, lordship,
legal aid counsel.
yes, lordship.
Pardon, Mr. Santiago and legal aid counsel for the applicant. And Mr. and Angami learned
K. Angami.
public, sorry, K. Angami learned public prosecutor. Angami for the state respondents. Full stop. The
Lordship, I am legal aid
LCR.
counsel only for this case, Lordship. I'm legal aid counsel only for this particular case, Lordship.
but legal aid counsel for
Yes,
this
yes, yes,
only. The pursuant to orders passed by this court, comma, the case record of ZR case number 27/2023 has been partially reconstructed perhaps with available materials collected from the sources, comma, indicated therein. Full stop. When it was admitted, Mr.
It was admitted on 22/3/2023, my lord.
As the appeal has already been admitted on 22/03/2023, and LCR within bracket reconstructed are available, and the appellant is in custody since 23/5/2023 to 2003. 23/5.
22/5/2023, Lordship. It is reflected in the impugned judgment and order. The day he was taken under custody by the police.
And when he was produced.
And he was,
23/5.
and then he was transferred.
23/5/2023. I'm recording from my order,
My lord, my.
my own order, page 47. Let the appeal be listed for hearing. After weeks or even. After
For-
3 weeks.
for-
After
Admission hearing, my lord.
after 3 weeks. As a fixed item. Huh? Already admitted, it cannot be, it cannot come in the admission part. As a fixed item, my lord. Considering, having regard to the fact that the appellant is in custody for more than 20 years, comma, Resti shall make endeavor to prepare the paper book within such period of, within a period of 3 weeks.
Deeply obliged.
Item number 5.
Yes, Mr. Seki, do you have the original copy of this document? And have you translated?
Your Lordships, I have made some translation, but before that, if my lords may allow me to place a communication of the government of India.
Yes. Is Union of India is a party here?
This communication has been issued to the states and union territories after the NCT norms became functional, my lords. I believe the NCT has been functional, the directives has been functional since 2001,
Let me read it then.
my lord, your lordship.
Mr. Seki, to forward your case, I think your Union of India should be a party. Union of India is a party or not? Because
Your
to
Lordship.
my understanding,
My lord.
this type copy at 142,
Yes,
it is
Lordship.
only a part of the original one,
Your Lordship. Your Lordship.
part of original one.
That is up to the
To
qualification
my
of Ratna.
understanding and to the best of my knowledge, it contains another part which says that this equivalence is recommendatory. And this is subject to the decision of the state government. To the best of my knowledge, from my practice days, I am saying that
My
this
lord.
is only part of it, page 142. Are you saying that this is full copy?
That I can't say, Your Lordship, and I was
That
trying to
I'm-
get the entire
because
document.
It
but I
has
could not.
neither head nor tail. It has neither head nor tail.
I agree with Your Lordship.
So I think to assist your case in the line of this one,
My lord.
I think Union of India should be, this is my suggestion, it is up to you.
In fact, I was
Okay.
getting that feeling last evening when I was going through the
Union,
documents. that
I also had the feeling,
The Ministry
that
of Human Resource
if
Development.
they certify you that, yes, you have WADA qualification is equivalent to degree or whatever with Hindi,
Yes, Lordship.
then it closes your case.
My lord.
As simple as that.
Yes, Lordship.
Yes, I'm supreme. Otherwise, this is only a part of it.
Yes. Otherwise,
Not a head, not a tail.
but your lordship, if we read this is also, it's only just saying that it is only equivalent to BA degree of an Indian university.
Right.
It is only in respect of the Hindi
Yeah, right.
examination, not of the full-fledged.
Mr. Seki is resting his case
Yes,
entirely on the premise
Yes.
that his qualification
yes, is
is equivalent to a degree qualification with
Yes.
Hindi as a subject.
exactly, lordship, yes,
And this is a matter which
Yes.
is best left to the expert.
yes,
Now, it is only the state or the central government who can declare equivalence.
yes.
Law is
lordship.
settled.
Yes, lordship, yes,
Now, if you come to Mr. Seki,
Yes, Lord.
if you come to the rules, rules are at 2017. Page
152.
150. Now, page 152. Here you read Rule 2, Roman 13.
Yes, Your Lordship.
Roman 13.
Degree of a recognized university.
Ah.
Means degree of a university incorporated by an act of the central or state legislature in India or other educational institutions established by an act of parliament or declared to be a deemed university under the UGC Act
Last part.
1956.
Or
Or an equivalent qualification declared as such by an order of the government.
so
Yes, Your Lord.
Nagaland government does not have any order. Right?
Yes, Your Lord.
Giving equivalence to your qualification.
My Lord.
To sustain a challenge for Rule 7B, whatever, you have to get this central government
As a
perhaps
party.
is a party responsible. If they declare, yes, we have declared, then as per list 2
My Lord.
of 7th schedule, entry I have forgotten, maybe 25, that will prevail.
My Lord.
If that prevails,
Then
your
the case-
challenge will prevail,
Yes, Your Lord.
right?
Your Lord.
State has said that what will be equivalent qualification if we pass an order. That order is absent. In that case, this one page 42, I think you should. Yes, that, firstly, that full copy of this page 142 should be placed.
Madam.
And second, it is up to you regarding, that implementing,
Yes, your lordship.
implement. Otherwise,
Lordship, this one, it is in my affidavit in opposition. Yes, page 14.
is it there?
Yes, yes. This is the Ministry from Education and Youth Services, page 14. Yes. This is dated 18 February 1970 to the Education Secretaries of all state government union territories. Permanent recognition to the Hindi examination conducted by the voluntary organization run on. Lordship, the type copy is at page 15. Sir, I am directed to forward herewith a copy of the press note issued by the Government of India granting permanent recognition to the Hindi examinations conducted by various voluntary Hindi organizations for purposes of employment under the government. I am to request that similar action may kindly be taken to grant permanent recognition to this examination by the state government union territories. This is signed by the Undersecretary to the Government of India.
Right.
Page 16, Your Lordship. Yes. This is serial number 1, that is name of the organization. We are concerned with this serial number 2, Rashtra Bhasha Paracha Samiti Warta. Then name of the examination recognized, that is Ratna. Then standard of Hindi prescribed in the equivalent exam. Standard of Hindi prescribed in the equivalent exam, that is at BA. Then the next page on page 20. This is the original press note. The type copy is at page 21. A number of voluntary Hindi organizations in different parts of the country have been conducting Hindi examination for a long time. In order that the candidates who pass this examination become eligible for employment in government service for which Hindi qualifications are prescribed. The Government of India, on the recommendation of the Hindi Shiksha Samiti and with the concurrence of the Union Public Service Commission, accorded recognition to the various examination of this organization, and a press note was accordingly issued in 1960. The recognition of some of those examinations was extended from time to time till the end of 31st December 1969 by Ministry of Education press note dated 15 May 1967. The Hindi Shiksha Samiti, which advises the Government of India on matters relating to propagation and development of Hindi, in its 21st meeting held on the 19th and 20th April 1969, had recommended that the examination which has been conducted by this voluntary organization for the last 10 years and which has been recognized by the Government of India for the last 5 years may be granted recognition on a permanent basis, subject to the condition that such institutions should continue to be inspected every year, and in the event of any grave irregularities being detected in the course of the inspection, action may be taken to withdraw the recognition. This recommendation of the Hindi Shiksha Samiti has been accepted by the Government of India, and in consultation with the Union Public Service Commission, the Government of India have decided to grant permanent recognition to the various examinations as shown in the annexure. It may, however, be clarified that recognition to this examination has been accorded only in regard to the standard of Hindi prescribed in the equivalent Hindi examination, and it is not to be treated as equivalent to the full-fledged certificate degree of the examination to which it has been equated. So even the ministry, the union also clearly says that Ratna, though it is a BA equivalent, in Hindi, it cannot be treated as a full-fledged degree course. That is our stand.
No, in fact, that is in my favor, Your Lordship, because I am not asking,
Degree is degree.
yes, Lordship.
And
No, my lord-
secondly,
yes, Lord.
secondly, you preface, the first preface, page 14, the original one,
Yes.
or type copy, page 15. They have given recognition. That does not mean that state, see, education secretaries. I am to request you that similar action may kindly be taken to grant permanent recognition to these examination by the state union territories. That is why that I have referred to rule 213. 213 and order of equivalence to be passed by the state government
Yes, Lordship.
in the rules, 2017 rules.
Yes.
And that is the clear stand, specific stand taken by the state government. And it says, that is what, this is a point for you, that this press note says it is not equivalent to degree. The central government is saying, Ministry of Education, Government of India is saying that clarified. So it is maybe equivalent to Hindi standard of graduate course,
Yes, Lord.
but it will not be treated as a degree.
Indirect, well, if we are applying for the job where BAs are applying, Lordship. Here we're talking about strictly applying to the post of Hindi teacher. And my lord, may kindly have a look at the loose sheet that I have just submitted to your lordships.
It goes also like that.
The paragraph 3, my lord. The paragraph 3, if I may be allowed to read. The recognition of the examinations as mentioned will, however, was limited to specific purpose of teaching Hindi. So we are only talking about teaching Hindi, Lordship. Not
Teaching
beyond that.
Hindi, but you have to see the NCTE rule and NCTE regulation. It governs the field and which says that it is mandatory to have a degree. Tell me from anywhere, this is not degree, your document. Tell me where from you can say that yes, my thing has been recognized as a degree, because that had you been permitted to appear and to get admitted into B.Ed course or to appear in the TET course, TET examination, that would have cleansed the issue. Yes, but indirectly it is treated to be a degree. But your case, you have neither been permitted to pursue B.Ed degree, nor you have been permitted to sit in the TET examination.
Yes, your lordship. If my lord is fully aware of the school education department issues in Assam. In Assam, a person who has Ratna can go for TET, and that is according to the guidelines in Assam.
I'm not aware.
I have gone through the documents on the net this morning.
If the state government declares it,
yes, lordship,
then there is no issue for the court. If the state government, because in Assam, there is a body, Assam Rashtra Prasar Samiti.
Lordship.
That also conducts examination. Probin is equivalent to MA. They say, but not the loose interpretation. So if the state government declares Probin to be equivalent to MA, then it is okay. But otherwise, Mr. Seki, UGC Act says degree can be conferred only by university or a deemed to be university under Section 3, who has been set up under Section 3 of the UGC Act. That is clear.
Yes, your lordship.
So your is by no means degree until and unless you have been treated to be equivalent by expert body like central government, MHRD, state government. State government is not coming to your aid.
Yes, your lordship.
Not coming to your aid. Only central government, your only assistance that could come from the central government. Sukri is not in your favor.
Even if we uh, assume that the petitioner has a BA degree right now. Despite of that also, they do not have BA. So where is the question? And
That is why I'm saying.
so my prayer is.
Had Mr. Seki been permitted to pursue BA degree, plus permitted to sit in TET examination, we could have impliedly assumed that he has degree. But he has not been permitted to pursue BEd course, nor he has been permitted to sit in the TET examination. How can we treat it as an equivalent?
So my prayer is that the school, we are facing shortages of teachers because there are 58 posts of ED teachers. So my prayer that the matter may get heard and today, Your Lordship.
Your Lordships, for the satisfaction of the Honorable Court as well as in the interest of my clients, the petitioners, I may be allowed to make the Ministry of Human Resource Development a party. Because, Your Lordship, if we go by the argument of the state respondents, and I'm not going into that now, if not, the state's affidavit is also misleading, the private respondent's affidavit is also misleading, self-defeating. In fact, if we go by the certificates, many of the private respondents, they have the same certificate as my clients, the petitioners, Ratna, with the same subjects. But since
Must they have a degree, perhaps?
yeah, they have Parangat, but they don't have BEd. None of them have BEd equivalent. They have the equivalent certificate, but none of them have that. And their affidavit is also a self-defeatist affidavit. But for clarity, as my Lord has rightly pointed out, I may be allowed to make the Ministry of Human Resource Development a party so that this issue will no more be a bone of contention between the petitioners who are pursuing Hindi course.
That prayer may be a reasonable one, because if suppose this petition is dismissed, next recourse is to the Honorable Supreme Court of India.
My lords, I'm for some of the private respondents. Here, my lord, kindly permit me to give one submission. Even if my learned friend was allowed to implead the central government, lordship, what purpose would it serve, lordship? Because even assuming, but not admitting that, if at all the central government was represented and this court was to come to a finding that Rakna was indeed equivalent to a graduation also, still, lordship, the petitioners lack BEd, lordship, and therefore that would not serve any purpose for the reason that they are still not qualified to apply for this post. Also, lordship.
Let us see your qualification. Let us see what kind of qualification you have. Let us see.
Lordship, yes, the private
Let
respondent.
us see private respondent number 5. In respect of whom you are making allegation?
All the private respondents, none of them has BEd except Parangat. If we are to strictly go by the rules, if we are to go by the rules, BEd is the only qualification, and if Parangat is not equivalent to BEd, if Ratna is not equivalent to BA, if Parangat is not equivalent to BA, then none of the private respondents also qualify, lordship. That is the tricky situation here, lordship. So in fact, my submission, if accepted, is in the favor of the private respondents, because I do not have Parangat. So even assuming that I do not qualify, the rule is still ultra vires.
Do you have Parangat?
No, lordship. But here, according to the rules,
document produced by you goes in their support.
yes. No, lordship. That same principle of 1988, read with the 2003 notification that I have just placed before your lordships, read together, lordship, it proves to show that the Rule 7B, clause Roman 4 and 5, it is still against the, not just against the petitioners, but against the private respondents also.
Come to page 16 of their affidavit.
16. My affidavit, lordship.
No, their affidavit.
The private respondent. Parangat,
Parangat.
equivalent to BEd. But this is not BEd, lordship.
Your document produced before the court.
Yes, it is in their favor and it will also be in my favor, lordship, once I have Parangat.
But you don't have Parangat.
At the moment, your lordship,
No,
But-
why? How can you stall? You get Parangat and take part in the examination. Whenever
I beg your lordship
This
to
is
kindly,
this stalling a process.
no, your
This is clearly
lordship.
stalling a process. Your document, this document clinches the issue that they have the B.Ed.
Sure.
Central government has declared it. Parangat is equivalent to
B.Ed.
B.Ed.
Yes, lordship.
So they have undertaken it. If you have Ratna, and if Ratna permits you to undertake B.Ed, go and pursue B.Ed.
Your
How
lordship,
you are challenging this?
your lordship, the rules. If my lord may kindly read the rules. The rules does not recognize Ratna or Parangat lordship. The state rules.
Come to the constitution. Come to the constitution 7th schedule. Under which entry education is? B.Ed falls under secondary, primary or higher?
That will fall under the secondary lordship.
Cannot be. Degree is higher education, Mr. Council.
Higher education lordship.
Higher education. Degree education is
Good.
higher education. It is controlled by UGC and other equivalent bodies.
I'm talking about school lordship, about
No.
where to teach.
No,
Yes,
B.Ed
Lord.
degree, Mr.
A
B.Ed.
higher education, yes, lordship,
And B.Ed degree means higher education.
my lord.
And higher education means union list, come to union list or concurrent list. Maybe around 50 entries. 50 something. Like that. Higher education. List 1. Yes, list 3.
I don't have the constitution copy with me right now.
Entry 25. Education. Including technical education, medical education, and universities subject to the provisions of entries 63, 64, 65, and 66 of list 1. That is central government, union.
Lordship.
List 1, 63. '66. Coordination and determination of standards in institutions for higher education. And degree qualification comes under higher education. And central government has the power. And its decision prevails over
The state. And the union territories.
ordinary, subject to. So this has been declared by central government. This Parangat is equivalent to BA degree of an Indian university.
So is the 142, my annexure at page 142, the type copy, Lordship, that is also.
That
same lines.
interpretation has been explained by the affidavit in opposition, annexure to affidavit in opposition. That is not equivalent.
For your Lordship, my Lord will kindly appreciate this. This issue is not just an argument between the councils and before the Honorable Court. It is going to impact thousands of people, not just the students, Lordship.
That
The
is
interest of
why-
the students
that
alone
is
does not
why I
arise,
have-
Lordship.
That is why, Mr. Council, I have taken you to the
Yes,
list,
Lordship.
list 1 and 3 of the Constitution of India, 7th schedule.
Lordship.
And that is why I have taken you that 7B. Because you are challenging a virus. Either if the repetition is allowed, it will be benefiting somebody, and a big group would come into competition with other group. And if your case is dismissed, your career prospect is likely to be affected.
Thousands of
I know,
careers will be
I
destroyed,
know,
Lordship.
but question is, all these are regulated by either the state government or the union government. We are not here sitting as educational experts.
My Lord.
That I have been saying time and again.
Yes, Lordship.
If you go through all the decisions, equivalence of qualification, Supreme Court has been time and again saying that court is not expert, and the field for equivalence of recognition or qualification should be best left to the expert. Right?
Lordship.
Now, expert from a prima facie view, experts are not treating in our qualification as an equivalent qualification to a degree. So how do you overcome it?
Now, your Lordships will kindly appreciate this fact, which I have repeated over and over again, that this is in respect of teaching Hindi subject. Now, if we go by the notification, the Government of India's notification of 1988, or the communication that I have just produced before your Lordships, this equivalence is in respect of only teaching Hindi subject. So that is why, as far as equivalence is to be understood from the other side, the argument of the state, we're not asking to be treated as equivalent to BA to apply for the jobs where BA.
Leave aside
Yes,
other
Lord.
sides.
Yes, your Lordship.
The court is asking. Please bring all those decisions of involving NCTE,
My Lord.
Supreme Court, where Supreme Court has given stamp of approval that to the NCT regulation, which says about that degree is a mandatory qualification for being appointed as an assistant teacher.
My Lord.
Sitting here, I am not in a position to bring that. Yes, Mr. Counsel, the decisions of the Supreme Court. Do you have those?
Yes, my lord.
Approving the stamp of approval to the NCT regulation that degree qualification is a must for being recruited as an assistant teacher in a secondary school. Well, series of arguments will not prevail if
My
the
lord.
NCT regulation,
Lordship.
have you referred to NCT regulation?
Yes, Lordship, I have gone through some decisions, but as my Lord has rightly pointed out, the court is not an expert to decide which qualification is to be equated to the other qualification. It is for the union and the state. And I have relied on some documents, but for clarity, as I have begged your Lordships may kindly allow me to make the union also a party so that the interest of my clients, the petitioners, thousands of them, their future also would not be jeopardized, while considering the interests of the students. The interests of the petitioners may also be taken into consideration, your Lordships.
Because, Lordship, even in my affidavit, I have annexed, my apology that I have not annexed the full, but I have annexed the relevant page of NCTE, where in order to be admitted, admission to BA degree, a person should have a bachelor degree, your Lordship. That is at page 13 of my affidavit. Page 13, this is norms and standards for Bachelor of Education program leading to Bachelor of Education BA degree.
This is appendix 4 of which?
Of the NCTE, Lordship, of the NCTE in my.
Oh, they can see me.
So, Lordship.
Give the opportunity to us also to go through the brief. Is it not?
Yes.
Piecemeal document, which is very difficult. Mr. Petitioner has submitted at 142, page number 142, taking out a part of a document. You have annexed a part of a document, and we are not experts in all these educational matters.
So even here also to be eligibility with at least 50% marks, either in the bachelor degree or in the master degree or any other qualification equivalent are eligible for.
Okay, you implead by to God of.
How can they hear me? How would I know
Let
that
us
they
have
can
a
hear
word
me?
from Ministry of Human Resource Development.
Even this, the letter which
It goes in their favor.
it is only in respect of KHSM Agra. Recognition was
Not
given.
Wardha.
Agra. It's the question of recognition of the teachers training courses, please. Hindi Shiksha Praveen, Hindi Shiksha Parangat, and Hindi Shiksha Nishnat, run by the KHSM Agra.
Not
Lordship,
Wardha.
yes. So
They are having from Wardha.
so, Lordship, okay, if we now assume that they have the BA equivalent, but still then they do not have the BA. So where is the legality, where is the locus? They are not an aggrieved person to challenge the virus of the service rule, Lordship. And because of this repetition pending,
Yes,
the result
Mr.
cannot be
Council,
declared.
locus is doubtful.
Lordship, if I have no locus, locus is only to do with advertisement, not with the rules, Your Lordship. As far as the rules are concerned, no, Lordship, as the senior counsel for the state, my learned friend should also assist the honorable court in a very free and just manner, because I'm as an officer of the court. Now, strictly speaking, Lordship, since I do not have Parangat, even though that Parangat is also not recognized by the state, since I do not have Parangat and Parangat being a must, let me fairly submit, Lordship, that I may not be qualified to have locus to challenge the advertisement. But as far as the rules are concerned, Lordship, there is no recognition of Radna also. Most of the private respondents in their affidavit, they have annexed the documents, they have Radna and Parangat, both are not recognized by the state,
My lord.
Lordship. Then if I have no locus, do they also have locus?
Mr. Seki,
My lord.
that is why I had taken you,
My lord.
to the entries in the seventh schedule
Lordship.
to say that so far as higher education is concerned, it is in the union list,
My lord.
entry 66, and as in exercise of that power, the Ministry of Human Resource Development, Government of India, can declare equivalence to a particular degree. So BEd forms in the higher education area. So it is the MHRD who can declare equivalence. They have already declared equivalence
My lord.
because of entry 66. So that will prevail because list 3, entry number so and so of the state list is subject to entry 66 of list 1. So this argument fails. This argument, this Parangat argument, that does not survive.
And Lordship, in our affidavit also, we have categorically stated that BA or MA with Ratna and BA are eligible to apply. So petitioner has only Ratna, no
Where is
BA.
that? Where is that?
That argument is also going to harm many private respondents, Lordship.
Let them
Paragraph four.
harm. We're not here to decide anybody's case sympathetically. We have to decide the case only
Page
on legal
Lordship.
parameters.
Page 4 of my affidavit, Lordship. The last paragraph, page 4, the last paragraph.
No, let us see that original. Where is the original advertisement?
Lordship, that is at paragraph 2.
No. In the read petition.
Paragraph 3 petition.
Where is the advertisement? There is advertisement or simply you have challenged the rule?
I have challenged the advertisement also initially, Lordship. But since the state is very apprehensive, in all fairness, Your Lordship, let the results be declared, Lordship. I have no issue with that. Because as far as the qualification of Parangat is concerned, if we strictly go by the state's argument, Lordship, results cannot be declared because Ratna is not recognized, Parangat is not recognized. But in all fairness, Lordship, I have gone through the affidavits of the private respondents also, the state also.
Mr. Counsel,
Yes, Your
the
Lordship.
private respondent, they have joined the party
My Lord.
process, right? By impleading yourself.
Impleaded by the court, Your Lordship.
Impleaded by the court. So you did not implead it initially.
Lordship.
Your case is confined to advertisement and Rule 7B, so and so and so.
Yes, Lordship. Yes, Your Lordship.
Let us decide. Yes, what submission you have more.
So, Your Lordship, if we go by the state's argument, it is harming not only the petitioners,
Or
but the
otherwise,
candidates. who they
your challenge to rule may remain, we can keep this pending.
Yes.
Yes.
But in the meantime, the interim order,
Can be vacated. If it is vacated.
if you want, then I can permit you to implead. Central government gets something from central government, then thereafter make yourself eligible and participate in the further process. Obviously subject to the outcome of the writ petition. That can be
In the meantime, Lordship, of course, my learned friend also has to be careful with the approbation and reprobation, because one way
No,
she is
Mr.
saying
Singh.
that I'm not equivalent, the other way around, the state. One way the state is saying that my qualification is not recognized, the other way around, they are accepting the same qualification that I have by the private respondents as an acceptable qualification. How is that possible, Lordship? That's why, Your Lordship,
I may be
in
allowed
all
to-
fairness, if I may be allowed, my learned friend. In all fairness, I'm saying that as an officer of the court, I have to assist the court without any malice, without any ulterior motive, and with all cleanliness, with
Mr.
clean hands. Hence, Your Lordship,
Mr.
results may be
Mr.
declared.
Seki, I had a glance
Yes, Your
at
Lordship.
the documents of the private respondents, right?
Lordship.
One thing is that they have a degree from an university. Right?
They have Ratna the same qualification.
1 minute,
My Lord,
I thought I went by your submission.
my Lord.
Now come to say page 15. You all have degrees from the universities?
Yes, ma'am. We are all graduates. Some of us have graduated in Hindi, some with Hindi as an elective subject, and some who have not graduated in Hindi, or some who have not
No,
graduated.
you have a degree university,
Yes,
degree
ma'am.
from a university?
Yes, my lord. Absolutely.
All of you have a degree from an university
Yes, my lord.
and plus some degree with Hindi as a subject
Yes,
or some
Yes.
with the graduation with Ratna
yes, yes.
and also B.Ed qualification
Exactly.
Not
as a
B.Ed,
Parangat.
Parangat. Yes, Lord. My Lord.
That your case is different then.
Lordship,
We can take up it for final hearing or we can modify the interim order.
he is casting an aspiration upon me. I'm saying, I want to make my clarification. I'm saying that Ratna is equivalent to BA for the standard of Hindi examination.
That is what
Not
consistently
that,
submitted.
yes. So I've been saying that if he has BA with Ratna and BA, he will be eligible, but he has only Ratna, Lordship.
Lordship, perhaps my learned friend's argument now has become more reasonable. That is actually what I want. Because what they are saying is that if we go by the service rules, going by the service rules, Ratna is not recognized, my lords. Parangat is not recognized. Hence, I'm saying that the rules are ultra vires. And it is a violation of Article 14. That's what I'm saying, your lordship. Because if this rule prevails, tomorrow also the state will again say that Ratna is not equivalent and they are not, it is not recognized, a recognized qualification. The same argument is going to come tomorrow, my lords. And
Where is the interim order? There is no interim order. Where is that?
in fact, it is subject to the outcome of the writ petition.
Where is that?
Your Lordship on 2/8, na? 2/8/2022.
2/8.
Yes. To 8/22. The last
Aye.
second paragraph. Lordship, here the second last paragraph, considering the fact.
Which page, which order?
Oh, not to declare the results, yes.
2/8 in the IA.
I think it is in the main.
IA Civil 121 of 2022, lordship. The order is dated 2/8/2022, my lords.
Considering the facts and circumstances of the case and the rules under challenge, we direct the respondents not to declare the result of the interview as far as individual teachers' post is concerned till the disposal of this petition. So we have conducted everything, but we keep the declaration of result.
Yes, two options, Mr. Seki. I am giving you two options. Firstly, the entire petition or modification of the in this order 2/8/2000.
Worships,
On the basis of pleadings, which one? First, you tell me.
may I be allowed to place one document for your lordship's perusal on the similarity, the same documents that we have, that the private respondents also have. I have made a translated copy because my learned friend has said that he is a graduate. If he is a graduate, we are also graduates. Now, as far as the modification of interim order is
So,
concerned.
Mr. Seki, now
Yes,
I am giving you I am asking you for the last time.
My lord,
Show me for any certificate of any of your petitioners from a university.
comparative study lordship.
No comparison.
Yes, all our certificates are university certificates, lordship, up to Ratna, lordship. That is why, lordship, I'm trying to show your lordships the same.
We are
documents.
taking up the repetition itself. I gave you option, since you have not
No, I beg your-
answered to me
My sincere
in
apologies, your
a
lordship.
proper manner, trying to divert the issue, so I am taking up. the-
I was not, my
You
lord.
are-
My sincere apologies,
you
your
are-
lordship.
I have asked you very fairly.
No, lordship,
You have taken, I have asked you that, do you have any degree from an university?
lordship.
What did you answer?
Our certificates are university certificates, lordship. That is what I've said, lordship.
Yes.
Hindi university
Proceed,
certificates.
proceed.
No,
Main report.
however, my lord, I beg your,
Prosecutor, I have heard enough.
I beg your lordship sincere apologies.
I have
Lordship,
heard enough. I have understood.
Your lordship.
I have understood to an extent. Let us complete
lord.
the hearing.
My lord. Then,
completed.
Lordship, I may be allowed to show my certificates.
No, enough. You have annexed whatever is there, we'll
Yes,
take
Your
up
Lordship.
all these documents. We'll consider all these documents.
Then may I place
If
the
any
private
statute
respondents
is
documents?
available, if any statute or
Lordship.
any public document, you place it. Not private documents.
Well, Your Lordships,
No, it's Do not. We do not.
Your Lordships, I do not want to argue after offending the honorable court. And since it is the interest of my clients, there are thousands of them, Lordship. So my lords may
No,
kindly, Your
we'll,
Lordship.
Mr. Seki. We'll consider only the legal aspects, nothing
Lordship.
more than that.
I may be allowed to implead the union as a party, my lord.
I gave you two options.
Lordship.
You have not answered to me. Either a repetition or modification of the intent.
As far as modification is concerned, Lordship, I have already considered earlier, my lord.
We'll modify that. Then you are at liberty.
Lordship.
Had as Mr. in the WPC. Had Mr. J. Sheki, learned counsel for the petitioner. Item number? Okay. Learned counsel for the petitioners. MS V. Sukri. Learned additional advocate general. Nagaland. For the respondent number 1, 2, 3, 4, and Mr.
Ali Zakir.
Ali Jakir,
Yes.
learned counsel for the respondent number.
I'm for 47 of the private respondents and they are not in order. It's the not respondent numbers are jumbled up. So shall I
Yes.
also,
Yes.
Lordship, in the cost list, 2 of the private respondents who I'm not reflecting, I'm not representing are reflected. So
You give me a sheet of paper. And for that deletion of them, you make an application before the registry. I'm not going to do all those clerical things. You give the respondent number whom you represent. Learned counsel for the students. The petitioners have laid challenge to rule 7B Roman 4 and rule
5.
7B Roman 5 of the Nagaland School Education Service rules, 2007, a set of rules framed under the proviso to Article 309 of the Constitution of India. And also to an advertisement dated 16/3/2022, whereby the state respondents have advertised for filling up of vacancies in a number of posts of graduate teacher in the post of. The petitioners are having Ratna qualification
Yes, Your Lordship.
from the Rashtrabhasha Prasar Samiti Wardha. Post of. It is the contention of the petitioner that the Ratna qualification is equivalent to BA, and the same has been declared by the Ministry of Human Resource Development, Government of India in wide it's circular dated 5/5/1988, right?
Yes, Your Lordship.
Within bracket and page number annexer 23 at page 141, that's 142. It is submitted that the rules to make it short, NSC service rules, earlier. The NSC service rules, rule 7, Roman 4, and rule 7B, Roman 4, and rule 7B, Roman 5. Declared the Ratna qualification as equivalent to graduation, despite the declaration made by the MHRD, GUI. Mr. Seki has thus submitted that in order to substantiate his case, case of the petitioner, the presence of the Ministry of Human Resource Development, Government of India would be a necessary party, and he has sought for leave to implead, the Union of India in the MHRD as a party respondent in the instant petition. MH Sukri, learned additional advocate general, Nagaland, representing the state respondents, has submitted that a process of selection has already been undertaken, and the same has almost finalized, and due to an order dated 2/8/2022 passed in I
121.
121.
121 of 2022.
22. The state selection process have not been taken to its logical conclusion. Keep it like that now. Keep it like that for the time.
Your Lordship,
Okay, and I
beg your Lordship's indulgence on one point. In all fairness, my submission may kindly be recorded. In all fairness, that in the course of the arguments and this case being taken up, I have come to a realization that since my clients do not have Parangat, which is equivalent to B.Ed, and for teaching in the high school students, that is necessary.
I am recording in the IA.
Yes, Your Lordship.
I have dictated this part in the main WBC.
My Lord.
Right.
Yes, Your Lord.
Now I am taking up this IA because it has kept pending, right?
Your Lordship.
It was kept pending, is it not?
Yes, Your Lordship. Your Lordship.
This was not disposed of.
So, Your Lordship, the challenge to the rules, I may be allowed to withdraw the challenge to the advertisement, Lordship, the challenge to the advertisement, because we do not have Parangat, none of the petitions.
Okay, then we can pass this order.
Yes, Your Lordship.
In the main petition itself. Main petition itself, he is not laying challenge to
The
second part, second prayer,
The advertisement.
advertisement. That is fair enough.
My Lord.
Yes, MS Supreme. So they may compete in the next stage, but okay. Mr. Seki, learned counsel for the petitioner, has submitted that it transpires from the documents submitted of some of the private respondents that they so for private respondents that they have a qualification titled Parangat
Yes, Lordship.
from Kenrio, which of Kenrio Hindi Shikshan Mandal Agra. Huh?
All the private respondents have Parangat, Lordship. May not be all from Agra, that university. but-
Okay. They have Parangat qualification.
Yes, Your Lordship.
And as per order number F.3-28/2003-DI within bracket capital L, madam, of the Ministry of Human Resource Development, Government of India, the Hindi Shikshan Parangat course is equivalent to B.Ed degree of an Indian university. Full stop. Though as the petitioners do not, admittedly do not have the B.Ed qualification in terms of clause, rule
I
7.
beg your apologies, Your Lordship. Parangat, if my submission is.
Parangat, hardly. Okay. Full stop. As one of the essential qualification prescribed in the advertisement dated 16/3/2022 is B.Ed qualification, the petitioners do not have it has been expressed by the the petitioners are not pressing the challenge as regards the advertisement dated 16/3/2022. Full stop.
Except for petitioner number 17, Lordship, who has both BA, B.Ed and Ratna.
Only one person, one of the petitioners, she says that she had, but she has not completed BA. So in my affidavit, I stated that she is misleading this court because she is only in fourth semester when she applied for the post. Yes, she does not have.
What semester? Anyhow, Your Lordship, I'm sorry for repeatedly. Yes, Your Lordship,
Yes.
interrupting the honorable court. However, if, as far as B.Ed is concerned, I'm against that. That's why I'm challenging the rules. But my fair admission before this honorable court is that we don't have Parangat, which is equivalent to B.Ed. That is the reason why I'm recalling the challenge to the advertisement. But as far as that language B.Ed, if it is put, then my petition will become infractious. So since we do not have Parangat, which is equivalent to B.Ed, we want to.
As the petitioners do not have Parangat qualification, the petitioners are not pressing the prayer of challenging the advertisement dated 16/3/2000.
And the subsequent advertisements.
Any other subsequent advertisement was there?
There has been subsequent advertisements, Lordship, the
As regards,
addendums, corrigendums and all.
as regards, okay, then as regards the following prayer. Okay. Page 22, only item 2. Item 2. Your
Yes, Your
prayer,
Lordship. Prayer.
without prejudice to their challenge to as regards virus of Rule 7B Roman 4 and Rule 7B Roman 5 of the NSE Service Rules 2017.
My lord.
First of all, as the petitioners are not pressing their challenge as regards the advertisement dated 16/3/2022, it appears proper, for ends of justice, to modify the order dated 2/8/2022, passed in the connected IA interlocutory application, IA civil number 121/2022, wherein it was observed that the respondents, wherein it was directed to the state respondents not to declare the results of the interview as far as Hindi graduate teachers post is concerned till the disposal of the writ petition. The as the petitioners have dropped the challenge as regards the advertisement seeking to fill up the vacancies of the then available vacancies of Hindi graduate teachers, the order dated 2/8/2022 passed in IS civil number 121/2022 stands modified. By stands modified to the extent that the state respondents would be at liberty to proceed to take the selection process initiated by the advertisement dated so and so. Advertisement initiated by the advertisement 16/3/22. Okay. Prayer I have already quoted. Initiated by the advertisements, mentioned in prayer number 2. To its logical conclusion, full stop. It is however made clear that any appointments made would be subject to the outcome of the writ.
No, they have not participated in the exam since we did not accept the application, so they have not participated in.
Okay.
Lordship.
Then not subject to the.
Even the presence of the private respondents will become unnecessary in the further proceedings, Lordship.
He may take instruction and stay here. 1 minute. In the main requisition, in view of this order, the connected interlocutory applications, IA civil 121/2022 stands disposal. This is disposal. We have passed the main order. Okay. Mr. Sheki, Learned Counsel for the petitioner shall file, is permitted to file appropriate pleadings seeking implement of
The
Ministry of
Human
Women
Resource
Resource Development, Government of India. Within a period of 2 weeks,
Madam.
2 years. Good stuff. Anything else?
No, my lord. I'm deeply obliged. Lordship, in view of this order, my name may be struck off from this petition.
You file a application. File a application
I will-
seeking deletion of your name.
Lordship, Lordship.
Okay.
Or motion item.
Yes, I'm Sukri. Or Union of India. This motion,
Motion.
you'll be there. Oh, Livika,
Yes, Your Lordship.
okay. Yes. VC. Yes, we can only issue notice.
Your Lordship, the petition, district petition has not been accompanied by the condemnation petition as well as the state petition, Your Lordship.
Is it
There's a delay, Your Lordship.
delay?
Yes, Your Lordship.
When is the judgment?
Judgment is at,
Date of the judgment?
Your Lordship, they have not marked the page, Your Lordship. The judgment is at 29.
Date. Ah, 2009-2023.
Yes, yes, Lordship.
Okay, we are in November.
Yes.
Is there any comment there? When this appeal was filed?
It was
Yes,
filed
Mr.
yesterday.
Counsel.
Monday, Your Lordship.
Monday. It was intra-party, they were the petitioners,
Yes, Your Lordship.
then. Limitation period is
1 month, 30 days, Your Lordship. And they are seeking for stay also. The
Yes,
petition accompanied by state petition.
unless it is not condoned.
Yes, Your Lordship. It's a matter of 23 days, but
Yes.
still they have to come.
Yes, sir. Here was the condition. Yes. What did
If I may be
you,
allowed, Your Lordship, to go.
what do you say about this limitation?
Lordship, if I may be allowed to call the leading counsel, Your Lordship. Lordship, if it is not filed within the time, Lordship, the leading council is willing to file the continuation of the Lordship.
Then next week,
Next week, Lordship. Apply tomorrow.
as, what is his name?
Nipendra Roy.
Huh?
Nipendra Roy.
Nipendra Roy.
Yes, Lordship.
Okay, Mr. N. Roy,
Yes.
a learned counsel for the appellants has appeared through virtual mode, assisted by Mr.
Medovero, Lordship.
Medoiron, learned counsel for the appellant, and MS Livika, learned counsel for the state respondent.
Only for number 4, Your Lordship.
Okay, for the respondent number,
4.
learned state counsel for the respondent number 4. So, as sought for by the appellant side, let the case be listed before in the next week.
Yes, Your Lordship. They have not filed the state petition as yet.
If they file, we file. Otherwise, you again raise the question.
Much obliged.
Apply tomorrow.
Keep again. Two more. No, order or no, 11, what about 11? Pass it. 11.
Oh, hearing. Item number 11.
Yes. Your Lordship, so the crux of my case is that in 2012, the petitioner number 1 to 4 were appointed in 2004 on contingency basis. 2004 by the director. The other petitioners, the remaining petitioners, they were appointed by the chief medical officers. At that point of time when they were appointed, there was the notification for such appointments permitting the CMOs to appoint was in place, Your Lordship. The Lordship, the appropriate word. Financial and cognate powers, Your Lordship, I'm sorry. Financial and cognate powers had been given to the CMOs for appointments, Your Lordship. And that was in place. Only in 2010, that power to appoint was taken away by way of an office memorandum, but the petitioners, the other, apart from the 4 petitioners who were appointed by the director on contingency basis, initially, the other petitioners who were appointed at that point by the CMOs, the power to appoint was inherent with the CMOs at the time they were appointed. So what happened was all these other petitioners were appointed on temporary basis. The 4 petitioners who were continuing on contingency basis, they were also granted a temporary appointment by the CMO. Now in 2012, what happened was the department decided to put the present petitioners under vigilance inquiry. So
matter was put up before the vigilance. And then immediately after the vigilance took cognizance, the vigilance also without going into all the records, if your lordship will see the vigilance report. From the vigilance report itself, it is very clear. They have just gone through the petitioner's appointment, and since there is no vacancies shown against which they were appointed, the vigilance also gave out a finding that these people, they were appointed without there being any post available. Now, based on that, the show cause notice and then the pay held up was embossed in respect of the petitioners. Then immediately after that, the department started making appointments, grade 4 boss, the present private respondents. All of them were appointed after the petitioners were placed under a kind of moratorium by withholding their pay and salary. And then show cause notice was issued. Show cause notice at the same time, the memorandum was issued, the impugned memorandum, the petitioner submitted a reply. By that time, the petitioners had received information that other appointments were going on. So the petitioners obtained by way of RDI all those fresh appointments. And they included that in their representation that if this is going on, the department is saying that you cannot, our services, the department cannot bear the cost of our salaries, whereas on the other hand, you are making all these appointments, fresh appointments after our pay has been held up. So it would be unconstitutional as well as a violation of our fundamental rights if these fresh appointments are retained and we are.
Let us see the judgment.
Yes. Lordship, my representation.
Let us see the judgments first,
Yes.
impugned judgment.
Impugned judgment is at page 385, okay? Page 385, annexure 9. Page 385.
Finding is at paragraph 21.
Yes, yes.
Hmm?
Yes, Your Lordship.
So five issues,
Yes.
all
Yes.
five were decided against you.
Yes, Your Lordship.
So the other respondents, because you were not appointed against any sanction.
No.
So apparently the single judge has held that you have no legal right to
Yes.
continue in the post.
Yes, that is that.
Second issue is that you have been given the opportunity. At
Yeah.
least the principles of violation of principles of natural justice was not there. You have been given so-called notices
Yes, we were.
and you have submitted reply. So
Yes.
that opportunity was there.
It was
It-
there,
it was
but,
given.
but they ought to have dealt with the points which we have raised. That was our only case.
But
Our
first
case,
issue, legal right, no legal right. Thirdly, first come, first go.
yes,
That since it is not that you had any post, you were
Yes.
holding any post. So, and second part, they were not appointed in the post or whatever, non-existent posts which were held by you.
it is unclear, yes.
But
It is unclear.
they are also temporary.
Yes. So,
It is not that first come, first go.
Your Lordship, but my other case is,
Had it been the same
Yes.
offices,
Your Lordship,
had it been the same offices where you were appointed, one could have drawn a presumption that, yes, you were replaced by another temporary or ad hoc. But they were appointed in some other offices.
Your Lordship, it was under the
Maybe
Mokokchung district, under the.
for
CMOs.
if there is
Yes.
need,
Yes,
government has that discretion to appoint.
Your Lordship, they have that, but in this case, all these appointments were also done backdoor, Your Lordship. They were also done backdoor. Now, without.
Whether
their
these
signature-
persons were served or not,
Your Lordship,
notices were served.
Yes, notices were served, Your Lordship. Your Lordship was sitting here.
Whether they were working,
They are still working.
mister.
Yes.
But since you have no legal right to maintain the petition itself,
No, Your Lordship, we have a right to be at least considered against those posts also. If not, at least give us a chance to compete for those. Since we have also been working earlier, that is my only case, Your Lordship. They ought to have at least considered our case. It is not that our appointment was met. It is irregular appointment, Your Lordship, irregular appointment. Even in the case of the others, it is also irregular appointment. Now throwing us out while retaining them.
no, when you were appointed between 2004 to 2009,
9, yes,
and when they were appointed,
2012, after our pay was held up, they were appointed. Your Lordship,
but before your dismissal,
before our dismissal,
and
they were appointed.
not replaced by ad hoc.
But it.
They may face the same music, there is a different issue. They may face the same music some point of time.
Your Lordship,
But it is not that during the currency of your appointment and prior
Yes.
to your dismissal,
yes,
pay may be held up. Ultimately, relief has been granted to you. regarding
regarding
pay.
the pay, yes, but
So it cannot be said that after your termination, they have been appointed.
it was because our pay
And
was held up, obviously it can be.
In exigency of
Yes.
situation, one office may appoint, government may have the discretion, that much is available to the
Yes,
government.
but they are continuing till today, your lordship. They are continuing till today. Those appointments, they are still continuing, and some of them were even appointed. The appointment order is similar with the petitioners only.
Now, whether they have been regularized,
They are contemplating on regularizing them, your lordship.
then you just
Yes,
tell him.
now, so. I
That
only-
liberty will be reserved to you.
Your lordship, if we may also be given the opportunity to compete for this post, because at least we have a right to be considered for these posts, against which subsequent appointments.
Yes.
Your lordship, here, the issue is very simple. And all the disputed issue has been settled. And WBC 162, and as pointed out by your lordship, para number 21 of the judgment. So my submission here, my lord, is the appellant cannot equate with the subsequent appointee because they were appointed with the government appointment. And present appellant, they were illegally appointed. So even to issue the issue of mandamus, and even the local sandies, it is very limited because they were illegally appointed. Their appointment is illegal. They cannot be treated as an appointee as per the LD. So they cannot be, even if they claim that they have to equate with a subsequent appointee, then that cannot be. And first come, last go, that theory cannot be applied.
That theory is not directly applicable.
It is not applicable because the thing is, of course, two ad hoc appointments. The appellant were illegal appointment. Subsequent appointment, they were appointed to meet the exigency with the approval of the government.
Okay.
So, yes,
Approval
that's the
of the
only-
government.
Yeah, once we can differentiate, this matter is very easy. So what is illegal?
So those were with the approval of the government.
According to the orders,
Subsequent.
yes. According to the orders, they are saying.
That's the
it
only
is-
issue here.
it is-
And
but
your appointment was by a CMO.
in the case of the four petitioners, they were appointed on contingency basis by the directorate. By the director.
Directorate is not government. He has no
He-
prior approval.
No, but prior to that, there was no government. Your lordship, I'll take your lordship to one notification. It came into effect only in 2010, whereby even the powers of the CMOs to appoint was taken away, and that the government has stated in that memorandum that henceforth all appointments will be after.
But there is a
government approval. But
distinction
prior to that,
between the set of petitioners and the respondent.
yes,
So far as petitioners are concerned, there was no government prior approval.
it was not necessary. It was not
Why?
necessary. Your lordship, I'll take.
At least they have at least a cover. They have a license,
Your
better
lordship,
license than you.
In a complaint came, your lordship. Based on this, it appears that this action was taken, your lordship. It appears from.
Where is that finding that regarding government approval about private respondents? Mr. Advocate General, Rizvi?
Six point two two, the one below, your lordship, memorandum dated 13 January 2010, your lordship, this is.
So this, your case attracts this
Next
one.
page, your lordship. Your Lordship.
So
So.
their case,
so from 2010 onwards only, government approval was required.
their case is covered by this.
Our case was prior to that, prior to this.
So-
2010,
First paragraph, first paragraph.
yes, they are. But
Government
then,
has taken a decision that all those irregular appointments made by them should be immediately cancelled by the administrative heads of department.
Your Lordship,
So
Yes.
this is a policy
inquiry
decision.
and inquiry is to be given now, Your Lordship. So far as
There is a
there was cognate.
clear distinction
Yes,
between you and the private respondents.
but we have also raised this issue, Your Lordship. At least give us a chance to compete for these posts. That was our contention before the department from the very beginning. We have a right to be at least considered since they are also irregular appointments. And since,
Firstly,
yes,
on the first hand, you were appointed without prior approval. One thing.
it was not necessary.
Secondly,
Yes,
it was not against any post.
Your Lordship, that is
Right.
what they are.
So suppose had there been post, then you could have competed in the post and you could have claimed preference weightage like that. But there is no post.
Your Lordship, it is questionable, Your Lordship. One thing, I'll take Your Lordship to
No
Annexure
post.
B. These
Show
are,
me so post existence of post.
Your Lordship, these are same appointments with the petitioners by the similar authorities. They have been left out.
Illegality,
No, I'm not
because some
saying-
illegal appointees are being allowed to continue. That does not give you right. So
Your
illegality cannot be part.
I know.
Negative plus negative doesn't
yes.
become positive,
I know.
Mr. Convener.
Declared equality, I'm not claiming.
You cannot negative.
Your Lordship,
please.
but since I have challenged their appointment, we have a
There is-
right to be.
We'll deal with that. We'll deal with that. It is clear from this office memorandum.
Your Lordship, but they were appointed without undergoing the normal process of selection. Selection was not conducted, only government approval. Their the government would just arbitrarily issue this approval without there being any exams conducted, no interview conducted, Your Lordship. No interview has been conducted. And they,
So, Mr. They cannot by no means can be termed as, or their services can be regularized.
Your Lordship, here. the
Only in exigency of service, but
Yes.
they cannot be regularized.
Your
and
Lordship,
then we also be given the opportunity, because now we are all overage, Your Lordship.
No, here also it says about against non-existing posts. They may be appointed in non-existing posts, but with prior approval. There is slight distinction.
So also in our case, Your Lordship, our case, if it is a non-existing post,
We'll observe that since they were not appointed by any kind of selection process, by no means they can be regularized in service.
and that we also should be given an opportunity to.
As and when because we do
And
not
now it
know,
is so many years, Your
No.
Lordship.
we do not know whether they were appointed against post, sanction post.
There are sanctioned posts, Your
No,
Lordship.
no, no.
We are being informed of, but they are
I am-
hiding it. They are hiding it.
Go,
That is
get
why
the-
they are regularizing this. This is what is going on in
No, no,
this state, Your
get
Lordship.
it
But
through RTI.
Your Lordship, I'll take your, with regard to.
No, this
petitioner-
has cleansed the issue, Mr.
Your
You
Lordship, with regard to
are
petitioners.
given for the,
Yes, but
this-
with regard to petitioners number 1 to 4, Your Lordship, I would like to place a citation, Your Lordship, that if they have been temporarily appointed, then they should be reverted back at least.
no, they,
Petitioners 1 to 4.
all their cases are contingency basis.
Yes, Your Lordship, even ad hoc appointments, same thing happened, Your Lordship.
No, every aspect has been dealt with, Mr.
Your Lordship, but Your Lordship,
Don't find any leeway
in the case of the,
anywhere.
in the case of the petitioners number 1 to 5, Your Lordship, the matter was heard, yes, but it was kept CAV, Your Lordship, and subsequently judgment was rendered, Your Lordship. So it was not an open court judgment.
So what
Now,
does?
Your Lordship, if Your Lordship may consider only one aspect, that is at least the petitioners 1 to 4, they were contingency appointed.
If,
They should be,
if suppose we can observe that if the vacancies are advertised later on, the petitioners should, cases of the petitioners should be considered for weightages. Weightages and relaxation of ages. We can observe that
yes,
much.
but
If in future, post or vacancies are advertised, right, in the offices where the petitioners were working, right? And in that case, the case of the petitioner should be considered for giving weightages and plus age relaxation.
Your Lordship, but with regard to the present, all these illegal appointments are going on and if no advertisement is made. But if they keep on.
To that
making
extent, Mr.
appointments, Your Lordship,
Congener, we can only observe that there, since they were also appointed without any selection process, but with the prior approval of the government, though their cases cannot at all be considered for regularization.
regularization
That I
without
cannot.
selection.
That I cannot.
And if.
This
selection-
much I cannot.
And if these vacancies are,
That much I can
Yes.
observe.
then,
That much weightage.
and then Your Lordship, with regard to the petitioners number 1 to 4, if Your Lordship may consider this, and if Your Lordship thinks it is,
Let us see.
yes, this is, I have given that. It's a very short. One, this is 2000 and 1995. Supplementary 2, SCP 759.
Okay, let us continue with the facts.
Your Lordship. In this case, an ad hoc appointee was regularized, but it was found that he was wrongly regularized. Terminated. The Supreme Court held that if the regularization is wrongful, then at least he should be
Mr.
reverted
Congener,
back to
now, nowadays you have to come after 2006.
Your Lordship, but.
So
in
the
this-
1995 is gone.
Yes, but since it is a contingency appointment.
Now
and
you have
it's
to,
a
you have to
petition-
confine anything after 2006 for SCC page 1.
Your Lordship, I agree with that, because under that, advertisement has to be made that no ad hoc appointments can be regularized. That is a fact, Your Lordship.
Come
But-
after Uma Devi, not prior to Uma Devi now.
But in this judgment,
That is 95.
At least revert him back to his.
Prior to
initial-
1995,
Yes,
this court was also issuing directions for regularization.
yes,
Subsequent to 2006, everything has been stopped.
Your Lordship, that is undisputed, but even subsequent to that, even ad hoc appointments. Ad hoc appointments,
You challenge the very
Yes.
decision itself. This particular office member.
Your Lordship, only recently I have come across this.
You challenge it. You challenge it.
But
How can,
if it is
how can the government,
yes,
by giving approval, can appoint ad hoc or work charge without any kind of selection process?
Your Lordship,
That
but
is-
if it is unconstitutional per se, there is no point in even without challenging Your Lordship's.
No, unless government
This
decision,
is.
there is
void-
presumption of constitutionality unless it is.
If it is void ab
set
initio.
aside.
It is. void ab
Unless it is
initio.
set aside.
That order is void ab initio.
No, no, Mahdevi said, it says that not regular, cannot be regularized.
Your Lordship, yes, but even
But
that,
suppose exigency arises. Government has the discretion to appoint somebody for
Yes,
for a period.
existency for a period, but now it is continuing for more than 10 years, your lordship. It is continuing for more
No,
than
I've
10
heard
years.
enough. Heard, Mr.
And your lordship, one aspect, with regard to salary.
Salary.
We have not been paid till date. Because.
Yes,
so-
Mr. Then why you are not paying? Have you initiated any contempt case?
We have not, because we have filed this application and then we are yet, because of the pendency of this appeal.
Since you have not appealed,
Yes.
Yes,
you must pay.
yes. So a specific.
Clear
time-
within a period of
a
3 months.
specific time frame may be
3 months.
given.
Art, Mr. Kongpok Ponjena. Learned counsel for the appellants. And Mr. Im Song, learned additional advocate general Nagaland. For the state respondents. Also. Though the respondent number 6, the notices upon the respondent number 6 to 41
Yes,
were served in the substituted manner
yes, your lordship. No,
by paper publication.
prior to that, by registered post through the.
Anyway, paper publication.
Yes.
None has appeared on behalf of the said respondents. Full stop. Para. This intra-court appeal is directed against a judgment and order, directed against the judgment and order dated 6/9/2019, passed in a writ petition, WBC number 162 within bracket K, stroke 2015. Post stop. The appellants herein were the writ petitioners in WBC number so and so. Post stop. The necessary of the facts necessary leading the facts leading to the institution of the writ petition can be narrated, in brief, as follows. Please take a seat. If something is to be pointed out, definitely you can. The writ appellants, that's writ petitioners. Within bracket hereinafter referred to as the appellants, for ready reference. Aim to be appointed in a number of posts purported in grade 4, in the establishment of the chief medical officer Mokok Chung during the period from 2004 to 2009. Full stop. The orders of appointment in the post designated as Chowkidar and medical attendant in respect of the petition number 1 to 4 were issued under the hand of the Joint Director Health Services, Kohima. First of all. On the other hand, the orders of appointment issued in favor of the petitioner appellant number 5219 were issued under the hand of the Chief Medical Officer, Mokok Chang. Full stop. The appellant number 5 to 19 were shown to have been appointed in the posts USTS like dresser, night chowkidar, medical attendant, laboratory attendant, and peon. Full stop. The appellant number 1 to 4 were shown to be appointed on contingency basis. Initially, after extending their services from time to time, they were shown regularized by orders, dated 25 to 2009, dated 25/3/2009, dated 27 to 2009, and dated 27/1/2009, respectively. Full stop. When the appellants were so continuing in the respective post, the Principal Director, Health and Family Welfare, Government of Nagaland, by its communication dated 30/4/2012, directed all the chief medical officers of the districts to hold up salaries of 150 number of staffs of the Directorate of Health and Family Welfare on the premise that their matters were under investigation by the Vigilance and Anti-Corruption Commission. Full stop. In the said communication, it was projected that the appellants were appointed without there being any sanction post. Consequent to the communication dated 30/4/2012, the Chief Medical Officer Mokok Chang informed, put the appellants on notice via the notice dated 18/5/2012 to the effect that they were purportedly appointed in non-existence post by the earlier Chief Medical Officer, and as an investigation was in progress. Full stop. on the ground that an investigation was in progress by the Vigilance and Anti-Corruption Commission, the Chief Medical Officer Mokok Chang, by his letter dated 18/5/2012, informed the appellants that their pays and salaries would be held up with effect from 1/5/2012. Petitioners were the appellants were thereafter, served notices dated 24/5/2012 by the Chief Medical Officer Mokok Chang, to appear before the Vigilance Police Station, Kohima, to report at the Vigilance Police Station, Kohima, along with their testimonials in original on 6/6/2012. Full stop. The appellants accordingly, appeared before the Vigilance Police Station, Kohima on 6/6/2012, along with their testimonials. Full stop. The appointment orders, the appointment orders issued in favor of the appellants, came to be seized by the officers of the Vigilance Police Station. Full stop. It is noticed that the Vigilance and Anti-Corruption Commission, after completion of the investigation, submitted an inquiry report before the Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department on 12/12/2012, reporting that with the observation that the appellants were found appointed by appointment orders without any mention or indication about the specific vacancies where they were appointed. Full stop. Finding themselves without salaries since 1/5/2012, the appellants submitted a representation before the Principal Director, Health and Family Welfare Department on 2/8/2013, seeking release of their arrear and current salaries. Full stop. The said representation stood forwarded by the Principal Director, Health and Family Welfare, to the Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department on 27/11/2013. Full stop. In the meantime, a screening committee under the chairmanship of the Chief Secretary to Government of Nagaland came to be constituted. And the said screening committee on 17/7/2013. Subsequent to submission of the inquiry report by the Vigilance and Anti-Corruption Department. Full stop. As per the decision of the said screening committee, The Principal Director, Health and Family Welfare Department issued an office memorandum on 5/5/2014. Wherein a decision was taken to serve notices upon the employees, notices of 1 month to those employees who were found to be shown regularly appointed without there being any sanction post. Full stop. A corrigendum dated 5/6/2014 was issued in continuation of the office memorandum dated 5/5/2014, wherein whereby a decision was taken to serve a notice of 1 month, a so-called notice of 1 month to the alleged illegally appointed employees under different in establishments of the chief medical officers, asking them to show cause as to why their services should not be terminated. Full stop. The show cause notices were thereafter, served upon the appellants, to which the appellants submitted their replies. Full stop. In the show cause notices, the appellants were informed that in the final report of the Vigilance and Anti-Corruption Department, it was revealed that a number of appointments in establishments of the establishments of the chief medical officers, stroke, what is MS? Medical surgeons under the Department of Health.
Superintendent of
Medical superintendents under the Department of Health and Family Welfare were found to have been appointed illegally. Post of encouraging a list of such employees, which included wherein the names of the appellants had also figured, the notices were asked to show cause as to why their services should not be terminated. Full stop. The show cause notice was of 12/3/2015, and the appellants submitted their replies on 26/3/2015. Consolidated.
Several times we have submitted. The first one is May
Full stop.
2014.
So these are the ultimate,
Yes.
final round.
Yes, we had to approach this honorable court, gave a
Correct.
direction and all those things were there, so
So-
3, 4 times we have
In
submitted.
short, I am
If your
recapitulating the
lordship
fact
may-
in short.
yes.
Full stop. After receipt of the replies, comma, the impugned order came to be passed on 29/4/2015 under the hand of the Principal Director, comma, Health and Family Welfare Department, whereby the notices were served with the so-called notices, including the appellant's hearing, were informed that since their appointments were made on regular basis without any sanction post, comma, they had been dismissed and their appointments were declared null and void. WEF 34/2012. Full stop. Para. Issuance of the impugned order dated 29/4/2015 led the appellants to institute the writ petition WBC number 162 within bracket K 2015 as the writ petitioners. Full stop. After exchange of pleading, comma, five issues fail for consideration before the learned single judge. Full stop. On the first issue as to whether the appellants were appointed against duly sanctioned post or not, comma, it was recorded that in the appointment orders issued to the appellants, there was no mention about any sanction order number of the post against which the appellants were shown appointed stroke regularized. Full stop. By observing that mention about the sanction post is normal practice, and in non-mention of the sanction number in the appointment orders stroke regulation orders of the appellants, comma, goes to establish that the petitioners appellants were found appointed against non-sanctioned posts. Full stop. it was held that existence of a sanction post is a sign to a non for regular appointment. Post. As the petition appellants were appointed, were not appointed against any specific sanction post, they had no legal right to claim continuance in those posts and have no legal right to seek a mandamus for that purpose. It was after perusal of the inquiry report of the Vigilance and Surveillance Commission and other related documents, the learned single judge did not find any reason to doubt on the findings made by the Vigilance Commission. As the Vigilance Commission was found to have conducted a thorough inquiry before recording its findings. It was observed that there could be no other conclusion other than the one that the appellants were appointed without any sanction post. As the petitioners were on the second issue, as to whether there was violation of the principles of natural justice, the appellants were found to have served with so-called notices and were found to have been afforded with the opportunity of making representation as the appellants were found to have been granted sufficient opportunities, the learned single judge was of the view that there was no violation of the principles of natural justice. One of the contentions, the main contention raised by Mr. Pongener and counsel for the appellants in this appeal is to the effect that even it is assumed that petitioners, the appellants, were appointed, the nature of appointment of the appellants were of ad hoc stroke temporary, etc. nature. The respondent number 5241 were also similarly situated. Full stop. Their nature of appointment, the nature of appointment of the respondent number so and so to so and so were also of ad hoc stroke temporary nature, and they were also appointed without any prior selection process. Full stop. In such situation, comma, the state respondents ought not to have terminated the appointments of the appellants. In view of the settled principle of law that one set of ad hoc appointees should not be replaced by another set of ad hoc appointees. Full stop. And to buttress his such submission, he has referred to an office memorandum dated 13/1/2010, issued by the Personnel and Administrative Reforms Department, Government of Nagaland. Full stop. Mr. Imsong Learned, additional AG, opposing such contention, has submitted that the appellants were appointed during the period from 2004 to 2009, whereas the respondents number 5 to 41 were appointed they are appointed during the period 12 onwards.
2012 to 13.
During the period from 2012 to 2013.
Yes.
Full stop. It is a submission that while in the case of the appellants, there was no prior approval of the government and they were appointed unauthorizedly by the director, chief medical officer, joint director, health services, stroke, chief medical officer, Mokok Chang. The appointments of the respondent number 5 to 41 were made only after prior approval of the government. And for exigency of service. Full stop. He has further contended that the appointments of the respondent number 5 to 41 were made in offices other than the offices where the appellants were serving. And as such, the principle that one set of ad hoc employees should not be replaced by another set of ad hoc employees would not be applicable in the case between the appellants vis-a-vis the respondent number 5 to 41. Full stop. Insofar as the learned single judge did not find any kind of discrimination committed against the appellants in view of the fact that the appellants failed to prove that they had any legal right to continue in the post against which continue in the post which were not sanctioned posts. The learned single judge had, however, observed that While deciding the last issue as regards as to whether the appellant should be entitled to their pay and allowances from the date their pays and allowances were held up, that is WF 1/5/2012 till the date their services were terminated, that is, 29/4/2015. The learned single just came to a finding that it is not a case of no work, no pay. You were working, huh?
Working, yes.
You're working.
Pay was held up.
It is not a case, it was not a case of no work, no pay.
Yes, yes.
Quote unquote. And as such, and since the services of the appellants were utilized by the state respondents during the said period, the appellants were found entitled for their pay and allowances during the said period by the learned single judge. Full stop. Mr. Pongener, learned counsel for the appellants, has however submitted that despite such a direction to make payment of the pay and allowances of the appellants for the period from 1/5/2012 to 29/5/2015 by the judgment and order dated 6/9/2019, the same have not yet been disbursed till date. Also. Mr. In Chong, learned addition advocate general appearing for the state respondent has submitted that he has no instruction as regards the same, but if such if the salaries of the appellants for the state period have not yet been disbursed the same would be looked into. Post para. Insofar as the contention raised on behalf of the appellants to the effect that the petitioners, appellants were replaced, should not have been replaced by the respondent number 5 to 41, on the premise, on the strength of the office memorandum dated 13/1/2010, this court is on perusal of the office memorandum dated 13/1/2010 is of the considered view that such convention does not have substance. As per the office memorandum, the office memorandum dated 13/1/2010 came to be issued after it came to the notice of the government that a number of unauthorized appointments had been made by certain heads of the departments without following the prescribed procedure. a conscious decision was found to have been taken thereby by the government, that all those irregular appointments made by such heads of the departments would be immediately cancelled by the concerned administrative heads of the departments. In addition to launch of criminal prosecution against the guilty officials. By the state office memorandum, in the state office memorandum, it was a decision was taken notwithstanding any provision to the effect that notwithstanding any provision in the delegation of financial and cognate power rules, as amended from time to time, the state government henceforth in all cases of appointments of government servants, either against regular post and on ad hoc fixed contingency basis against non-existing post, would be done only with the prior approval of the government to be conveyed in writing by the administrative head of department. The policy decision contained in the office memorandum was to the effect that thenceforth, any appointment made without prior approval of the government shall be considered invalid, null and void. And all such appointments of work charge and casual employees without sanction post shall also be done only within the strength approved by the Nagaland Work Charge and Casual Employees Commission. The main distinction in case of the appointments of the appellants and the appointments of the respondent number 5 to 41. Yes.
Your Lordship, I would like to take your Lordship to the orders whereby these CMOs were given the cognate powers to appoint. They were having that power. So at least that aspect should also be considered, Your Lordship.
Which one?
If I'll take your Lordship to page 322 and 323. This is order 322 is with regard to civil surgeons, subdivisional medical officer, and so and so. This is with regard to power of transfer, posting, placement, so and so, etc. But 323 and the type copy is at 324. Empowered to civil surgeon. The civil surgeon was renamed as CMO, Chief Medical Officer in Lordship, for appointment to fourth grade post. Delegation of Financial and Cognate Powers Rules of 1964. Governor of Nagaland, Kohima is pleased to direct the following amendments made in a delegation of Financial Cognate Powers Rules 1964. Appointment to class 4 staff, district level officers of various departments. So they had the power to, at least the power of appointment. At the time, the petitioners were appointed. Only in 2010, this power was taken away by the point of this memorandum. But prior to that, the petitioners were validly appointed by the competent authority. That is I would like to clarify that also.
Even reliance on the, reliance in an order dated 28/7/1999, whereby the Directorate of Health Services, Nagaland, delegated, powered, conferred. 322 is civil surgeon only.
Earlier, prior to CMO.
Delegated.
This is
Delegated.
the second.
The power delegated to the civil surgeons, within bracket, later on designated as what? Chief Medical Officer,
Yes.
stroke subdivisional medical officers. The power of transfer, stroke posting, stroke placement within the district, stroke subdivision for all the field staff available under their jurisdiction. And what is this, page 334?
This one is based on the last paragraph, Your Lordship, subject to budget provision and other conditions laid down by the government, why they are number, this is 1980.
Wait, this A2, very good to go. Page number 322. I go to bracket. And what is this? What do we call it? Is neither regulation nor so and so.
It is for.
UO, I think. UO to be the unofficial level. And the communication. What is the date?
This is based on in 1980.
I don't know where from you are taking it.
This is what is there in the civil surgeon's office. 1880. So this was in.
And the document. Shown to have been issued by the Secretary, Medical and Health, Public Health Department, within bracket, page 34. 324, whereby the financial and cognate powers were shown to have been delegated to district level officers in respect of appointment to class 4 staff, as the such powers cannot be exercised to make appointments in non-existent post. Exercise of such delegated power to make appointment in post properly in grade 4 without there being any sanction for such post is clearly an unauthorized exercise of power. Is a exercise of power, comma, not authorized by such order of delegation. Full stop. It has emerged that the appointments of the appellants were in offices different in offices other than the offices where the respondent number 5 to 41 were appointed. Full stop. From the periods of appointment of the two sets of two sets of contesting parties, comma, it has clearly emerged that the appellants were appointed during the period from 2004 to 2009, whereas the respondent number 5 to 41 were appointed during the period from 2012 to 2013. Full stop. Thus, comma, the principle that one set of ad hoc employees should not be replaced by another set of ad hoc employees is not directly applicable, found applicable in the case in hand. Full stop. The government has the discretion to engage any person in case of administrative exigency, be exigency as an interim measure of such appointment in certain situation in view of exigency of service, comma, could be without any selection process, full stop. But it is settled all that for any appointment in a regular post, comma, the constitutional principle embedded in Article 14 and Article 16 of the Constitution of India are to be scrupulously followed, meaning thereby, comma, there has to be a selection process, proper selection process with wide publication and with opportunities by providing participation, by providing opportunities of participation to all the eligible candidates. Full stop. Thus, it is clear that the appointments of the respondent number 5 to 14 cannot, comma, by any means, comma, can be regularized in any manner in the subsequent period, comma, full stop. This court is of the considered view that, full stop, in view of the discussions made above and for the reasons assigned, comma, this court is of the considered view that there is this court does not find any good and sufficient reason with the to interfere with the judgment and order dated so passed by the learned single judge. Full stop. Consequently, comma, this appeal is found devoid of any merits. Full stop. It is accordingly dismissed. Full stop. Para. While parting, comma, this court is of the considered view that since one minute. Let me finish, then something is left. You point out. While parting, this court is of the considered view that if the direction of the learned single judge to disburse the salaries of the appellants for the period from
1/5/2012 to 29/5/2015.
are not yet disbursed, the state respondents shall disburse the amounts to the appellants within a period of 3 months from today. Full
Now-
stop. I'm not finished yet.
Okay.
Though the appointments, though the services of the appellants came to be terminated by the impugn order dated so and so, the appellants had rendered their services for a substantial period of time without any misconduct on their part. Full stop. This court, in such fact situation, this court is of the considered view that in the event, in the event the responding authorities decide to fill up any sanction post in the offices where the appellants had served by a public advertisement and by selection process, the responding authorities shall consider giving weightages to the appellants for the services they had rendered for the period, and also consider in the matter of relaxation of age relaxation. Anything more?
Yes, that is what I was, since your lordship was dismissing the petition, I thought the matter ended there.
No,
But
no,
yes,
that's it.
they should be granted the age relaxation, yes. Because they are now all over age.
I have said that consider.
Yes.
There are circulars to that effect, and you can. But release their salaries. The other matter,
Item number 15.
what to do? Mr. Ponjina, he has gone. Please inform him that
Should next week.
Mr. Inchong and Mr. Ponjina, you will not get the order today because it has been dictated.
Your lordship.
It will take 2-3 days time to get the order, right? So,
Will apply accordingly.
Huh?
Will apply accordingly.
that you will apply accordingly, right? Yes, next week.
Yes.
Okay.
Dune judgment was passed by Justice Kohima. So most of the time he's sitting in. So next week will be the appropriate bench.
Okay. Mr. Limawapang, Council for the petitioner, Mr. E. Tivapong. State Council and Mr.
Sakato Chishi.
Learned
Private
Council for the respondent of court have made a joint prayer to release the case for posting the case in the next week. Next week? Next week, whenever, I don't know. Next week. As paid for, release the case in the next week. Huh?